All set? Good morning, everyone.
Morning.
It's good to see all 11 commission members in the same place. So thank you all. I appreciate the time everyone takes for this. We do have a full agenda, so we'll get going. Again, welcome, and I know I say it on occasion, but I certainly appreciate the time and effort that all the commission members put in this. As far as the agenda, first item is a review and approval of the meeting agenda. I believe the agenda has been provided to all the commission members. If there are any comments or discussion on the agenda? If not, do I have a motion to approve the agenda?
So moved.
All right, and do I have a second? All in favor?
Aye.
Anybody opposed? Next item we have is a review and approval of the draft of the minutes from our April 12th, 2017 meeting. Again, I believe those have been provided to all the commission members with your packets. Are there any comments with regard to the meeting minutes? And if not, do I have a motion to approve those minutes? Do I have a second? All in favor?
Aye.
Anyone opposed?
I abstain, no, wasn't there.
Thank you. First item, we have old business listed as number 4 on the agenda. The first item there has to do with the work we've been doing with regard to the familial search policy and regulations. The DNA subcommittee, at our direction, did consider this at their last meeting. They considered all of the suggestions and recommendations that the commission made. I did personally attend the meeting to make sure that they were aware of our discussions. They did make changes to the policy, and also corresponding changes to the regulations and the plan based on the input and the feedback that this commission provided them. They have sent us back a recommendation in the form of a binding recommendation with regard to a familial searching policy, and along with that policy, draft regulations and a draft plan. So at this point, is there any discussion with regard to the binding recommendation from the DNA subcommittee? Yes.
This is just a technical question, so I don't know that we're going to get the answer. We talked about the matching between the crime sample and the database being searched for familial, and as we only release the identities or make the list to consider release if they reach this established kinship threshold. And elsewhere in documents, there's this description of what that is. I would like to know in plain language, what level of relationship? Are these first-degree relatives only? Does the offender whose DNA we're saying is similar would have to be a sibling, parent, or sibling, parent, or child of
Sure.
who we're matching up? Because the way it's described, I'm just not sure how limited the match is.
It's going to be out of order, but the state police who are presenting their validation next will be able to address that point on.
But I see Ann's point. If she wants this information in order to make this decision, I don't see any reason why we wouldn't have the state police, to the extent that they can answer that.
Sure.
Answer.
And I believe they're in Albany, so you might be able to.
Yeah, so do we have someone from the state police lab there that can address this issue? Good morning, Ray.
Good morning. My name is Ray Wickenheiser. I'm the director of New York State Police Crime Lab System. So to answer Dr. Willys' question, we're strictly looking at a likelihood ratio, and a likelihood ratio is how many times more likely by the amount of sharing we see in the profile or increased sharing that this person is a relative to someone who is not a relative. So we're not specifically determining what that relationship is. Now, it's much more likely that it's somebody who has a direct lineage, like a father-son, or an immediate relative, but it does not exclude other possibilities. It's strictly on how much sharing and how much more likely that they are a relative. So we've seen that in the vast majority of those instances, there's a first-order relative, but just due to the numbers, it may be somebody that very, very unlikely, but possibly could be a half-sib. So very likely first order, but we're strictly doing it by a likelihood ratio, not by the actual relationship, because we are not going to be able to tell that.
But you could have set your threshold so that it would assure the likelihood would be of a first-degree relative only.
If I could
Well,
just,
again, that would be-
you said two things, I think,
Certainly.
in this statement, because you said that the likelihood would be, and then you said only. And as I hear those two things, they're two different things. You could set them so, I think one question would be, could you set it so it would only be a first-degree relative? The second one is, could you set it so that it's a high likelihood it is, which I think you just said they did.
Yeah, and first of all, it depends on what you're trying to test for. So what we did is we generated sort of a very large number of profiles for family members, just statistically, and tested those, as well as a number of what we knew to be is known relatives with people sort of interior known to the lab. So with those tests that we ran extensively, we're just really seeding the database and seeing how we can successfully find relatives. But just due to the random nature of how DNA is inherited, to be able to try to set that so you could only find certain kinds of relatives, that was not the premise of the validation. The premise of the validation is trying to find a location where we can find the relatives, and occasionally there may be people who may or may not be this kind of relative, that kind of relative that would creep into the data, so to speak. So that was not how we set our threshold. We set our threshold to try to capture the right balance of not a huge number of samples that we would be having to run with additional DNA testing, in this case YSTR, versus trying to get a large percentage of the people that would be included that would be relatives. And within the numbers of thresholds we're setting, we knew that there was a possibility that there would be somebody who could be a half-sib if they had a very kind of rare set of profiles. It would be extremely difficult to try to set those thresholds to try to exclude a certain kind of relative, because you'd be giving up other types of relatives that even more first order when you would be trying to set that threshold.
So I understand the answer to the question. What you're saying is that your net is being thrown far wider than solely for those with first-degree relatives. And that's,
I guess I
that's a
disagree.
decision that's been made, and that's fine.
Well, what I listened to Ray say, it sounded very different than what you just said to me. But I get, we can all take what we want from what he said.
What did it sound like to you?
It didn't sound like they set their net far wider. It sounded like they did a lot of work trying to find that spot that would give them these first-degree relatives. And in some very rare cases where you had rare issues in profiles, you might also get something like a half-sibling. That doesn't sound to me personally like a wide net, but maybe it does to other people.
If I could just interject, and I believe Chairman Green's characterization is accurate. I just want to be very upfront that we're not excluding someone when they happen to come in at a high likelihood ratio over the threshold. That we feel that this would be a very rare event. We're just saying it's not excluded. That there might be somebody with a half-sib relationship that would happen to have some rare alleles that might creep into there. But I would not characterize it personally that we're throwing a wide net. We're just trying to get as effective as a search as we can.
But a half-sib relationship is no greater than a aunt or uncle or cousin relationship. So if you're going to catch half-sibs, you're going to catch, potentially, in a rare profile, second-degree relative.
Is that true?
Yeah.
Is that true, sir?
That's not my understanding is a half-sib, you're talking about a half-brother, so somebody who has one parent in common.
We have 25.
You go to first cousins, we would get a wider distribution, but could you, in theory, have somebody who would be included in that if it's possible? But I feel like it becomes a little bit more remote, progressively more remote.
I think the likelihood is right. You can have half SIBs that have a higher likelihood ratio than full SIBs if the half SIBs share rare alleles. So setting a boundary specific to it.
I understand. We're just not, when we had our conversation at the last meeting, I did express the opinion that I thought it would be important to make sure we were limiting the fine to those who are potential first-degree relatives. And this threshold is somewhat less
Looser.
rigid than that. That's all.
I'm sorry, Mike. It seems like it's looser. In other words, one of the concerns that I have going into this meeting about familial search is it seems like a focal point of those who propose the use of this methodology is that you're protected from what is essentially a data mining technique by the stringency requirements at all different levels. And what I'm hearing here is three different things. I'm hearing what you think it is, Mike, what the gentleman in Albany is expressing he thinks it is, and what Ann Willie is saying it is. But in the end, what it comes down to is the net is a little bit bigger than we thought. It may not be a wide net, but it is a bigger net. And that seems to me to go against the stringency requirement. So my question is, why don't we make the net tighter so it's only the half SIB?
I guess when you say it's bigger than we thought, my own personal opinion is I don't think we knew. I think the state police lab was doing work through the course of the validation to try and come up with, where they felt those standards should be set. And until they did that, until they went to the DNA subcommittee, and the DNA subcommittee looked at it at their meeting and agreed, yes, we think this is reasonable, I don't think we knew where that net was going to be. So to say that we thought, maybe Ann thought that. I certainly had no expectation that the net was going to be any different. I frankly didn't know exactly where it was going to be until I saw the results of the state police work, and I sat through the DNA subcommittee, and I heard the conversation, the questioning, and I saw their binding recommendation. So I wouldn't characterize it the same way you do. I think that, we now know where the net is set, and frankly, it's a place that I'm very comfortable with. As Ray said, I personally think it strikes a very good balance between trying to make sure that we don't get too many samples and trying to make sure that it's at a spot that won't, for example, exclude the father-son relationship. I think they did a lot of work trying to find that sweet spot. And again, given everything I've read and given what I saw at the DNA subcommittee meeting and given their recommendation, personally, I'm convinced that they found that spot and that what they propose is very reasonable and is a good path forward.
Right. It's absolutely comparable to say what we do with newborn screening. We pick a threshold level to assure that we identify all those who might need to be identified, even at the risk of identifying a significant number that didn't need to be included. I mean, it's this sensitivity, specificity trade-off for what is your purpose. It's a level that I'm not comfortable with. Mike is, and we've had that discussion before, but that's fine. I just wanted to know where it was.
Marvin.
So let me just clarify one aspect of this past discussion. Is it your statement, Mike, that validation studies for this have been done?
Yes.
And we have the validation studies, or at least the DNA subcommittee went over the validation studies.
Yes. And correct me if I'm wrong, Ray, but I believe these studies were provided to the DNA subcommittee. I know the subcommittee reviewed them at the last meeting, but I believe were the entire validation study provided to the subcommittee?
That is correct.
And the validation studies that were used to determine the sweet spot that we're going to use if this is approved are going to be retained by either the DNA subcommittee, this commission, or by the state police. Is that correct?
They're memorialized in the letter that's in the next agenda item, and that is the approval of that process at those particular values. And then the way the policy, as we've described it, there's a 2-year review that encompasses it. So obviously, if there's modification that's needed at that 2-year review, you can go back and do that. So your question of, are these memorialized? They are. In the document, which is in your binder, I can give you the exact page if you want, and the policy will be approved at that level.
My question is a little bit more specific. The actual validation study, and let me, there's no secret
So I think
here.
let's ask Ray.
If I am a criminal defense attorney in a case, and I serve a subpoena on the state police for those validation studies, you'll be able to produce them. Is that correct, sir?
That would be something our council would have to deal with. The studies are complete. We have
But I
them.
think-
We submitted them to the DA
Right.
subcommittee.
Ray, if I can, the
Yeah.
question is, they exist and you're not going to change them or destroy them or do anything. They're going to be there. So if at the end of the day, there was a valid court order and your council told you to comply with it, you would have them to provide. Is that right?
Absolutely, yes, that's true, and we have that, which would be subject to all auditors having a look at. That's what we do with every validation study. We keep it, is available, and certainly we have it, and we've turned it over to DA subcommittee. Yes.
Okay, that answers that.
Any other? Yes, Ann.
One point, I think the last sentence of the document is now not consistent with one of the changes that we made at Ann's suggestion.
What page?
Page 16, the last sentence. So that was under the premise where the requesters would have to withdraw the request, and otherwise it would continue to be searched, as opposed to now where you can resubmit a request every 6 months, if I'm reading it correctly.
Page 16, you're talking about the last sentence.
The very last
And you're
sentence.
saying it's inconsistent with what?
With 5C2, which was changed to the requesters can submit a new request at a minimum of every 6 months or under extra circumstances. So that's minor,
What
that's
is
just
this
a word
document
thing.
here?
This is the main commission binder.
On page
No, no,
16,
but
we're
is
still
this the
saying
plan?
The
that
policy.
This is
the
the actual policy.
search will go on periodically without the request of the originator. We changed it, and it is changed elsewhere, to say it doesn't happen again unless the originator asks that it happen again.
Right.
And they can ask every 6 months or more often if. It's just a wordsmithing change, like, totally different subject.
Just to clean up the
Well,
document.
we should clean this up.
Yeah.
I think it's a valid statement.
Yeah.
Right.
It's good catch.
I'm
And
not
the
understanding
change-
what the issue is.
The
So-
correct
That's the
change
word
is
it
on page
11.
11.
On page 11,
Look on page
Five-
11,
five
it's
C.
crossed out.
2 was deleted, 5C2, but that same wording is on the last sentence on page 16. Such searches will continue until the request is withdrawn.
Good catch.
So if we can, just to be clear, back on the threshold issue.
I think we just have to resolve this one first.
Okay.
So if we could just take a look and,
You should wait in.
Yeah.
That's the right language.
Okay.
Can you say it, Brian?
So I guess it was just, you didn't change it properly. They changed it at the DNA subcommittee. Right.
Shelley,
how are they mutually exclusive though, right now?
We took it out on.
We took it out.
No, but if we look at the two things, I guess
They contradict each other.
It should mimic the wording that's,
The wording. They
Which is
changed
on
it at the
5C.
yeah,
DNA.
that's what I was just going to ask
It's
Shelley.
not.
Did the DNA subcommittee at the meeting change this one, do you know?
They did, they said to make the conforming
Well,
changes.
all of the changes we did are in red. This is the same document, so
That didn't get carried over.
it didn't get
So
carried over.
it's just a technical error, it's not something they didn't change.
Right.
All right.
I think they agreed to the
Yes,
change.
they
just
did.
didn't
Yeah.
make-
Okay.
Yeah, they did.
So the language then in
on page 11.
the language on page 11 under, it would be 5C2, that's underlined in red, the new language there. That should also be carried over to page 16.
Number 4.2.
4.2, all right. Yeah, let me just, the language in 4.2 to make it consistent should be struck out, and the language, the prior language just be inserted there.
Correct.
All right. And that is consistent with
What they did.
what the DNA subcommittee indicated they wanted done. All right. All right, so let's make that change. Thank you, I think that was a good catch.
And I had one more question, suggestion. So the outcome of these familial search cases are going to be reported to the subcommittee, I believe, once a year. And I think it's appropriate for the commission to also see that.
Yeah, I don't know that we need that in the policy, but I have no objection to that, and we'll make sure it happens.
Which is what we do with partial match.
Right.
All right, any other comments or discussion with regard to this, Marvin?
I wanted to return to page 8. To section, on that page, 1B1 and 1B2. 1B1 first, which deals with the requirement that the investigating police agency or the appropriatee must certify to the DCJS that reasonable investigative efforts have been taken in the case. And when we discussed this at one past meeting, I felt that that was a very loose and ambiguous term, particularly when we're dealing with this new kind of way of searching. Not so much a new methodology of DNA, which would be within the purview of the DNA subcommittee, but the way we're going to do and apply that, which is so totally different. And I expressed the idea that the requirement ought to be until all leads have been exhausted. And I expressed that in a letter language, which I know was sent to the DNA subcommittee. I think you've seen it.
I believe it went to everyone on the
And
commission.
it's in our book. And the specific section that I'm talking about in my letter is located on pages 45 and 46, in which I talk about this business of exhaustion. The only person so far who has really opined against the term exhausted was you. And I'm pretty sure my memory is correct on that. And your opinion was, what does exhausted mean? I mean, exhausted could mean anything. So I researched that, and in my letter at pages 45 and 46, I pointed out not only a dictionary definition of exhausted, but I also showed how in the Commonwealth of Virginia and in California's Department of Justice Division of Law Enforcement, the language used for this situation is exhausted. So I don't understand. Well, I do understand. The DNA subcommittee has made their recommendation, but we can disagree with it. And the term all investigative leads seems to me, or investigative efforts, to be totally flexible and could mean anything. And it should not be dependent on who's sitting in the chair where you are now, nor should it be dependent upon who the next DCJS commissioner is, or what the next governor appoints in terms of a philosophy, conservative, liberal, or otherwise. The reason we have these definitions and we argue over these words is because we're dealing with, in this case, a data mining concept. And everybody agrees, from everything that we've talked about, that we've got to be very careful with how we use this. There was one speaker at the joint public meeting between the DNA subcommittee and this commission who spoke about the racial implications of the use of familial DNA and the concern in the Black and Puerto Rican communities and communities of color that this could be used as a data mining search to sweep up people who are minorities. And that has been actually written about in many books, including Inside the Cell by Erin Murphy, a professor here at NYU. So I would like some clarification, given what I wrote on pages 45 and 46, which seems to in all respects show that the term exhausted is what has been used in other jurisdictions where familial searching has been approved. But here we're going to go to a different definition, which is much lighter. So why would we do that? Why would we want the term to be exhausted? Now, certainly of the two terms, exhausted versus reasonable investigative efforts, it seems to me exhausted is a little bit more stringent. And certainly it gives, if we pass this, a lot of power to you individually, not the commission, but you individually as the chair to make these decisions. I'm going to get to that in a minute because there's been expressions in the past that that ought to be in the hands of a judge, not the head of the commission. But putting that aside for the moment, would you change your opinion having read the letter and seen that other jurisdictions use the word exhausted to define this? And let me just remind you that one of the reasons we're sitting in this room today discussing this is because the case that was brought to our attention to focus our efforts on passing familial searching depended upon a representation that was made to this commission in a letter in December of 2016 by the Queens District Attorney that all efforts had been exhausted. There was no way out, nothing we could do. And then the letter was sent to us, we began to discuss this, and in the middle of discussing this, lo and behold, we find out all efforts were not exhausted. They had gone back, they had found a new avenue, and indeed, remarkable as it is, it was history repeating itself. It was the Son of Sam Berkowitz situation all over again. For those people who remember that, I'm sure the NYPD does, put a whole new cast on how we look at parking tickets. In this case, it was a summons that a lieutenant had given out to an individual, and that's what sprung loose the lead. So, Mike, I think exhausted is the term we should use. I don't think that's a defense term. I don't think it's a liberal term. I think it's a term that has been used in other jurisdictions with good reason. And so I'm asking this commission to not use in 1B1, instead of reasonable investigative efforts, the term exhausted. And if the power is in your hands, if we pass this, then at least you have a finite term, and there'll have to be a certification to you about what has happened. And I don't think that if the term is reasonable investigative leads, it impels you to look at the situation the same way as exhausted. Because exhausted would say, cause you, a former prosecutor, I might add, from Rochester, a major city in this state, a hub city, that it would cause you to say, when you say to me, Mr. Fitzpatrick, that you've exhausted all leads, have you started all over? Have you looked at parking tickets? Have you done this? Have you done that? Wouldn't that be the better way to go? No?
There is no such thing in investigating what I'll refer to as a cold case, or even a cold case, as having exhausted every lead. I've never seen it happen. That's why you continually re-examine cases, and another detective may look at a case that dozens of detectives have looked at over the course of years and suddenly come up with a new lead, with a new idea. You do neighborhood canvasses, and invariably you see, person not home, or a person didn't see anything. And you find out months later, weeks later, years later, that the person that wasn't home is an eyewitness, or the person that initially said they didn't see anything said that out of fear and actually did see something of significance. I can think of a case in my own jurisdiction where we had a guy who was a suspect for 25 years. His family was estranged from him because they thought that he killed their mother. It turns out the guy that killed this woman was, his DNA sample was found on a rag left at the scene. And it turned out to be a guy on death row in Georgia. And were all investigative leads exhausted? No, nobody had tested that rag before. So what I did was, and I only saw Marvin's letter a couple of days ago, what I did was I tried to analogize this to something that already exists in New York law. And that's a very, very intrusive invasion of a person's privacy that prosecutors are allowed to do. That's getting an eavesdropping warrant. You know that, Mike, Scott, you know that, and I know that. And eavesdropping warrants are challenged. And sometimes they are challenged. Did you follow the procedures set by statute? And what the statute says, and I'm quoting here from the CPL, is that we can't even request a warrant from Judge Mazzarelli until there's a full, and I'm quoting, a full and complete statement of facts establishing that normal investigative procedures have been tried and have failed or reasonably appear to be unlikely to succeed if tried or to be too dangerous to employ. Very, very similar to the language that we have employed here. And the Court of Appeals, naturally warrants are challenged all the time. In a case, People versus Rob, R-A-B-B, 16 New York 3rd, 145, said, although eavesdropping may not be used as a routine first step, now I'm diverting from the language, nor is familial searching a routine first step, the court goes on to say, law enforcement need not exhaust all conceivable investigative techniques before resorting to electronic surveillance. Their reasoning is the same as mine. There's no such thing as exhausting all leads. So if we change it to the language that Marvin requests, and assuming, make no conclusions here, but assuming we employ familial searching, somebody's going to get caught for committing a very, very serious crime in the state of New York, and that individual is going to go to court and challenge the legitimacy of familial searching and challenging the legitimacy of the process used to identify that person. And if I have to stand in front of a judge, as a judge, am I going to have a hearing? Did you interview every witness? Did you check every parking ticket? Did you recanvass the neighborhood? There's no such thing as exhausting every conceivable lead in a case.
If I can just add to that, we did, obviously Brian's staff did tremendous research, you know, in working with the DNA subcommittee to formulate the original draft, and we looked at what every other state did. So we were aware of that language. Yeah, but I share Bill's feeling, having worked on hundreds or thousands of homicide investigations and God knows how many other major case investigations. I can't say that I ever felt that I had exhausted every lead. If I sat down with any case, no matter how much had been done, and I put my mind to it, I guarantee you I could find other things that we could try and do, and we did that. You had cold cases where investigators who were very good investigators, working with very good prosecutors, said this case is closed, we can't solve it. And then we would pull them back out, we'd reopen them, and we'd find a list of 23 other things we ought to follow through on. And those didn't work, and it got closed again, and someone else pulled it out 3 years later and found another list of things. So if the language is exhausted, and I'm sitting in this chair, I don't know how I could ever find that someone met that standard. And I think the example you point out is a good one. I think Judge Brown in the Queens DA's office was very well intentioned. I think they did a tremendous amount of work on that case. I think none of that work at the time they wrote that letter had led to a lead that led to a suspect. I think they felt that they had exhausted things at the time they wrote that letter, but clearly in hindsight they hadn't. And I think if, this is just my own personal feeling, if the language in there is exhausted, I think we never do a familial search, because I don't know how I could say you've exhausted, because I could always look at a case, I think, and find something else you could do. So I share Bill's view on that. Mark?
So let's then make an appeal to the commissioners for flexibility. Of course, eavesdropping analogy falls a little bit short, because in this case, we're not dealing with a judge. We're going to place all of this power in a state official appointed by the governor. A little bit different than going before a judge, where you have to justify an eavesdropping warrant. But be that as it may.
You would ask for the procedure to be reviewed if you had a client charged as a result of familial search.
That's correct.
Okay.
But be that as it may, I'm a flexible guy. Let's adopt the language, instead of all investigative leads, let's adopt the language that you just read for the eavesdropping.
I think they're synonymous.
Well, doesn't sound synonymous to me, but you raised
We'll
it.
be a little flexible.
I am. I'm coming down from exhausted to the flexibility of the language for the eavesdropping warrant. Because I think that language is a lot better than reasonable investigative efforts. And if people are uneasy, such as the chair and yourself, with exhausted, then here we go. We have the language that Bill just read from the statute that the judges use. Let's use that language. And that, what could be bad about that? That's what the courts look to for eavesdropping. Surely that would show that the commission has taken this initial step, the very first step that has to be justified to you as the head of the commission. Let's at least adopt language that's less stringent than exhausted, which I think is fine, but you don't, and go with what Bill just read. What would be wrong with that?
Personally, I think the language we have in here sets a good workable standard. I don't see any reason to do it, but if you want to make that motion to amend it, to read that, you're certainly free to do that.
I must be candid with you, Mike.
You always have been, Marvin.
Right.
I would expect nothing different
Today is a
today.
day for ultimate candor. that I could go the route of making the motion, but I'm unsure in a vote that I think is going to be along the lines of 7, 8, or 9 to 1 eventually today, that I could get a second. Because I've seen that happen in this commission before. I, on the other hand, will always second a motion of any commissioner who feels that something's important enough, we ought to hear it. So, yes, I will make the motion and ask that the language Bill read from the eavesdropping warrant be adopted, and I will pray to the legal gods that one member of this commission, one of my colleagues, will second that motion.
Well, you don't have to pray.
Did you second it?
I wanted to have, is it appropriate for some discussion here? I just wanted to point out one difference that we didn't think about with respect to the eavesdropping applications. Everything I receive on an eavesdropping application is presented to me under penalties of perjury. It's all sworn documents. And that further, validates the information that we receive when we consider whether or not we're going to grant an eavesdropping warrant. They're not obviously, as you all know, they're not lightly granted. The applications, at least the ones that we receive here in the First Department, are very extensive, very thoroughly prepared. The investigative officer appears with the assistant district attorney, and all of the material is presented to us under penalties of perjury.
And for that very reason, the fact that in eavesdropping cases, a judge gets all sworn documents.
And we have someone to question, too.
Right, we don't have that in this situation. What Bill's talking about is me questioning this at the trial level, after the familial search has been
Which you
used.
also get to do in the eavesdropping situation.
Right. Now, to enhance the sworn document stage of this application, if we turn to page 46 of our book, I put in 5 different requirements that should be included as part of page 8's 1B1. And several of those requirements call for sworn statements, so that when Bill Fitzpatrick and the chief of police of Onondaga County get ready to make their application to you, they have to make a sworn statement. And now we could have such a sworn statement using the eavesdropping language, borrow the sanctity of the situation by having a sworn statement, and have that written into the recommendation. Does this seem to you, Mike, to be an outlier kind of recommendation, or does it seem to my fellow commissioners to be a reasonable exercise of power in a situation where prosecutors and police officers want to use a data mining technique for investigative purposes that will end up before a state official, one lone state official, who will make the decision? I would like your feelings about that.
And I would be happy to share them with you. Yeah, I think there are differences between the two situations. In the one situation, you're talking about the judge giving law enforcement permission to listen to all of your private conversations over your phone, probably for a period of 30 days or more. In this situation, you're talking about a search of the DNA database. I think that given what we are talking about, given the intrusion we're talking about, the protections that are set out in this policy are reasonable and appropriate. And I've reviewed your letter carefully. I've given it a lot of thought. I've reviewed every other policy in the country for every state that allows this. And I think that our policy strikes a very good balance and provides the proper protections given the level of intrusion that we're seeking to do here. Now, that's my personal opinion, but you've asked it and I've shared it with you.
Okay, so rather than prolong this, because I have other questions about this, let me make the motion formally that we change on page 8, under case requirements 1A.B.1, eliminate the term reasonable investigative efforts have been taken in the case and replace it with the eavesdropping language that was read by Bill Fitzpatrick. That's my
So
motion.
you made the motion, you have a second. Any other discussion on the motion? All right, all in favor of the motion? All right, 2, all opposed?
I think I lost.
So that motion fails.
I have another motion.
All right, can I ask this, if you have other changes, maybe if you could in one motion?
It'd be very difficult. I mean, I have a whole slew of them.
Yeah,
I'm happy to discuss them.
no, I just, if there's a way we can keep this from going to 5 o'clock tonight, that would be good.
I can be much shorter on some of the others. I really
okay.
have just the one I just talked about, which is on page 46,
Okay,
to take from my letter items 1 through 5 and include those sections as part of page 8, 1B1. So 1B1 would then have 1B1 A, B, C, D, E. Because I just feel that coming to you as prosecutors and policemen saying, we have used all reasonable investigative efforts with no sworn statements. We're just talking to you, we're telling you, there isn't even a requirement as to what they have to tell you. It's totally up to you. You know, it'd be interesting, Mike, if later on a trial were to ensue and there were a pretrial hearing where a defense attorney challenged this, how we would even find out what was happening. We wouldn't know. Fitzpatrick and the police officers show up at the DCGS office. They talk to you. You may or may not take notes. You may or may not have witnesses in the room. It does seem to me totally reasonable that we put in some kind of requirement that you take certain steps. That you take certain steps to create a record, and not only create that record, but preserve it so that prosecutors and defense attorneys who subsequently argue these things in a court of law, as they are wont to do, that there be a record there that we can all get our hands on.
Yeah, and I haven't pulled the language up, but as I read this, I know it talks about them making an application. Certainly my vision is that they're submitting something to me in writing. That, when I say application, I'm not going to be entertaining this as phone calls or conversations in my office. I'm not going to make these decisions without them addressing these things and giving it to me in writing. And I read this language, to me, that's what application means.
Which section are you now referring to?
On page
Go on
9, it says in
9,
the
yeah.
form and manner.
I'm sorry, what
On
page
page
are we on?
It says in the form and manner specified by the division.
Plus,
So the
when you
application
read
is-
it implies that it's written, because it says
Yeah.
upon receipt of the
Right.
application, the
Right.
completed application will be provided to the commissioner. When you read it, it implies that it's written.
I don't see any common sense reading of this that would be anything other than a written application. You look at all,
Then I'll tell you what, just in case, why don't we just insert the word, the completed written application, instead of oral application?
because there's no way oral application satisfies this.
There's no what? I'm sorry?
I don't see any way an oral application satisfies this language when you read it as a whole.
Sure it does. I walk in, I'm the prosecutor for County X.
Then
I
maybe
walk in with the chief
it's a
of
good
police.
thing that I'm sitting in this chair and not you, huh? Because
Right.
I'm not gonna, as I read this language, I'm not gonna take
On
anything but a
page
written.
9, it says the completed application will be provided to the commissioner of the division for review. So I'm not
Right,
sure how
I
a
read that.
completed application
I read,
could be
Oral.
oral. I mean, it's a completed application.
right, see, that's the problem. That's the problem.
Okay, I didn't see it.
A completed oral application. I don't understand the resistance to making a record on something that is as crucial as familial DNA, where we've always been, all the states have been incredibly cautious.
I think
Why
there's
not-
two
What
things
does it
here.
take to put in the word written?
I've got two issues here. One, I think this policy and the accompanying documents provide the protections that you're asking for in this instance. I don't see any common sense reading of them that would indicate that anything other than a written application would satisfy them. But secondly, we had a meeting, at our last meeting, where we asked the commission members to go through all of this material and make recommendations. We've gone through a long process here where we held public hearings with a joint meeting. We had the DNA subcommittee look at this and make recommendations to us. We purposely didn't have them do a binding recommendation so that this commission could then discuss it and make recommendations back to them. We had an opportunity for all of these things to be brought up so that they could then be sent back to the DNA subcommittee, so the DNA subcommittee could look at them, consider them, and send binding recommendations back to us. We went through all that, and you didn't raise this at any time during that meeting so that we could address it at a time when it could go to the subcommittee, they could consider it, and it could be taken into account before they send us back binding recommendations. We're now sitting here with binding recommendations in front of us, and as far as I can tell, for the first time you're raising this issue. And I think someone could look at this and say that this is just an attempt to derail this for another 3 months. And frankly, I think that
That's a little unfair.
we've gone through such a process, and I know I have at least bent over backwards to try and structure this in a way to give everybody all of the opportunity they could to have input at the right time. I purposely structured it not to have the DNA subcommittee send us a binding recommendation the first time so that we could do all of this. And now, we're sitting here, the things that you addressed in your letter, I was scratching my head when I read the letter, saying, why in the world weren't these things raised at the meeting when we had an opportunity to discuss them? So I find it a little frustrating that this is coming up now, but putting that aside, on the wait a minute, putting that aside, on the merits, I don't see any reading of this policy which would allow anything other than a written application to satisfy it.
Mike, can I?
Yeah.
I think what, and I'm not putting words in Martin, I don't think he's raising anything of an opinion any different than he raised previously. And what you're hearing is some commission members are still unhappy with the policy that's now come forward. Yes, the process means that this time it's a binding recommendation. That doesn't mean all of us like it. The letter was sent to the DNA subcommittee in hopes that they might have incorporated or considered it with greater than just to take the written comments from the last meeting of this group. So I don't think it's inappropriate for us to be discussing further
I didn't say it was inappropriate.
return of this document as now binding, as not accepted. I mean, we can call the question, we can take that vote. And
I think maybe that's the way to proceed.
If I just might, when I read this, from my perspective of how I read this type of language, through an application to the division in the form and manner specified by the division, my mind went to that the commissioner would issue some kind of a regulation, after whether or not this is adopted or adopted, that the commissioner would issue some regulations which would lay out what would have to be presented in a more specified form. That's how I read this as an opening for the commissioner's regulations, and that might satisfy.
That's exactly what we intend to do.
Yeah, that's how I read it. That would, I mean, to me, this has to be a written application the way it's written, but the exact form, the number of affidavits or whatever you eventually specify would be laid out in a regulation, because you want that to be a little bit more flexible, so that if you find that you're not getting enough information, then you would amend your regulations, which is an easier thing to do to increase the specificity required.
So, Mike,
Yes, Mike.
so let me understand. It is your intention to do what Judge Mazzarelli just said. After this meeting, if this passes, you're going to set forth a regulation. I don't know how you do that, but you'll set forth something in writing as to what it will take and the format to satisfy the requirements that we've been talking about before we can go forward on familial searching on an application.
Yes,
Do I read that correctly?
yes.
And is that going to be something that's going to be a year in the making, or it's going to be
No,
3 months from now, a month from now? I mean, I just want to be sure. I'll withdraw the written application.
No,
I can withdraw that if
I don't
I have that
imagine it would-
assurance.
I don't imagine it would take us more than a month to put that together.
so you're not talking about a regulation, you're talking about a policy of the
Of the commission.
Understanding between.
month. A regulation would take far more than a month.
Yeah,
Right.
there's gonna be written guidance from
Written guidance,
DCJS
okay, that's fine.
to people, because
But that's
put
different than,
yourself in my shoes. I don't want things scribbled on the back of an envelope coming
course you
to
don't.
me.
that's
You know, I
different
want-
than,
You gotta cover yourself.
Yeah,
All right. So,
yeah, but as Marvin said, I'm well aware of the fact that these things may be litigated, and I don't want to be called to court testifying in these things. But I'd rather have a full record of everything that was done in writing, so people can look at it, and not have me sitting there scratching my head saying what happened. And that's exactly what, as I read this policy, as we put it together, that was our intention, that was our understanding, that's what I think these words say.
so when you issue those policies in writing as to what you're going to require, will you share those with the commission so we can all see them?
Absolutely.
Okay. I will make no motion with respect to the changing 3C to written application. I haven't made the motion, so I'll just leave it alone for the moment. Let me turn to page 8 again to 1B2, exigent circumstances exist. And I think I addressed that in my letter at page 47. And I felt that exigent circumstances was way too loose a term, it was undefined. And I suggested in my letter to the DNA subcommittee 1, 2, 3 ways that we could deal with exigent circumstances. And Mike, I thought I did the right thing. I submitted to the DNA subcommittee.
You actually
the
raised
hope-
this one, I believe, at our last meeting. too.
Yeah, with the hope that they would adopt these. They didn't. So now I'm bringing it up to you.
Marvin, the term exigent circumstances has a long established meaning in the law.
It does.
People versus Payton, right? You know the case.
Okay.
United States Supreme Court. You have to have exigent circumstances to go into somebody's home without a warrant,
Correct.
right? We know what that means.
My suggestions only do not deal with the actual term exigent circumstances. They deal with certifying in writing the following. Precisely what you talked about a few minutes ago. Having a seriousness to the application that causes it to be treated by law enforcement making an application to a state official under the same conditions as if we were doing an eavesdropping warrant to a judge and presenting sworn statements. So all that I do on page 47 is suggest more language to be a little bit tighter.
But
That's
your
all I did.
language doesn't define exigent circumstances.
That's correct, because
It doesn't meet what the term exigent circumstances and the way the United States Supreme Court defined it isn't met by your 1, 2, and 3.
the conditions for the exigent circumstances are what are described in 1, 2, and 3. That's all I'm asking. I don't think that's an unreasonable request. So,
Again, my personal feeling on this, as the judge said, I think exigent circumstances is a term that's been defined through case law for years and years now. I don't have the year on Peyton off the top of my head, but I think it's probably 40 years old or
At
more.
least, the famous case is people versus
But
Payton.
Marvin's request that this be written, documented in writing can be part of your application policy.
That the exigent circum,
Yeah, yeah.
absolutely.
Oh, yeah.
Yeah,
So,
oh, okay.
it can be
Yeah,
dealt with.
no, I,
Yeah.
you
all
add
of
that?
this, if there's a requirement in there that something be shown before the search can be done, it's my reading of this, and it's my intention in carrying it out, that all of this has to be laid out in writing. So if they say they made reasonable investigative efforts, that's gonna have to be spelled out in writing in the application to me. If they say there's exigent circumstances, what they think those are gonna have to be spelled out in writing to me before I would approve any of these.
and these rules or guidelines, they would be the policy of the commission.
I believe the application goes to DCJS, so I have no problem sharing with the commission, I have no problem getting the commission's input, but at the end of the day, I think they're DCJS guys.
So what does it become, a policy of DCJS?
Yeah,
Okay, as opposed to a state regulation under the NYCRR.
correct.
Okay, and you intend to include exigent circumstances as I've outlined in some format.
Well, it has to, by the terms of this policy, exigent circumstances is one of the things they have to show. Anything that needs to be shown to me, I interpret this to require it to be done in writing, but just so there's no ambiguity,
Okay.
we will put policy or guidance out in writing from DCJS that I will share with you first, making very clear that factual allegations supporting any of these things that need to be shown have to be set forth in writing in an application to me.
Okay, that's fine. So that leaves me with, there's no one else who has comments at one last area that I want to touch. So on pages 43 and 44, I raised the issue of whether or not the commission and the commissioner have powers under 995A to even entertain familial searching. And I raised that issue because I read the statute, and the statute enumerates in very specific terms what powers the commissioner has. And throughout 995A, it says the commissioner must, or the commissioner may. And the legislature was rather specific. The other aspect of this, with respect to the authority of the Commission of Forensic Science, the other aspect, whenever you're ready, Mike.
No, I'm ready, thank you.
The other aspect of this is familial DNA searching, as we understand it, requires that a sample under changed parameters is examined in the database, not for the purpose of a match, but rather for investigative leads of people who have been convicted previously and who might be related to the unknown sample. So my question is, and I raised it in pages 43 and 44 of my letter, was how do you square 995, I think it's D, with the authority of this commission to use the DNA database for investigative leads and not for a match? Now, clearly, in 1994, when the DNA Federal Act was passed, it was subsequently amended in 2006 to permit partial match searching. And partial match was in fact adopted by this commission with a series of policies. I think we have a partial match policy here in New York State. But familial DNA is a totally different animal, because we know that we're not looking to do a match. So the first question is, how do we get around 995D? That's the first thing. The second question I pose to you is, doesn't the commission, in order to have a policy on familial searching, have to operate under a statute or a regulation? And do you know, as you sit here today, if such a statute or regulation exists in New York that authorizes this commission to engage in familial searching? I certainly can answer the first part. There is no statute. But I am not sure about the answer to the second part, that there's an NYCRR regulation. And my third question to you is an NYCRR regulation crucial? In fact, is it not a prerequisite before this commission can act on familial searching? Doesn't the governor or the state legislature have to enact a regulation that allows us, this commission, to operate and put forward a policy on familial searching? Those are my three questions.
So as to the statute and the authority, 995 is within Article 49B. Under the grant of authority, when the legislature passed that statute, this commission obviously oversaw the database being set up, the parameters under which the database could be searched. At one point, the commission created the subject index, which was not at all mentioned in the statute anywhere. There's nothing in the statute that specifically said you can create a subject index. That exercise of authority by the commission was challenged, and in Gallo versus Pataki, the court held that the executive law article 995B, in which 49B, in which 995 is encompassed, represents a large-scale delegation of authority regarding the operation of the data bank to the commission and DCJS. This commission, under that same authority, under Article 995B and Article 49B, and specifically Section 995, again, as you indicated, adopted policy and regulations allowing partial match searches, or partial match associations within the DNA database. And again, there's no mention of partial match in 49B or 995. There was no amendment by the legislature allowing that, but the commission did it. It's been in effect for some time. And again, it hasn't been challenged, and it hasn't been challenged because I believe Gallo versus Pataki made clear that the legislature, in setting up the scheme that they set up, delegated decisions like this to the commission. And I don't see what we're doing here with regard to familial searching is being any different from what the commission did in setting up the subject index, or being any different in what the commission did in adopting the guidelines with regard to partial match. So as I read 49B and 995, and as interpreted or defined in Gallo versus Pataki, I think 995 gives this commission the authority to do it. Now, does that preclude the legislature if at some point in the future they decide they want to take this issue up and set their own parameters from doing so? Absolutely not. But until that time, I think 995 is a broad delegation of authority to this commission to address exactly these type of issues.
If I may?
Absolutely.
By sheer chance, I happen to have a copy of the decision in front of me.
I'm sure it wasn't by sheer chance, Marvin.
Well, it wasn't by sheer chance, it was certainly by sheer. And I listened to your analysis.
Because you're a good attorney who's prepared.
I listened to your analysis, and I find it compelling, with one major exception. You left out that the subject matter index that Gallo versus Pataki talks about only came about after Governor Pataki issued an executive order on December 5th, 2005. Executive Order number 143, 9 NYCRR 5.143. This executive order directed the creation of a fourth DNA index. It was under that NYCRR executive order that Gallo versus Pataki talked about what the commission could do, or DCJS, I should say, not the commission. And the issue there was a parolee who was contesting whether or not his DNA could be tested as a reasonable rule and regulation. And indeed, he lost, because the court found, and this was a miscellaneous case, Judge Schneier. This miscellaneous case out of Kings County said that pursuant to that executive order, creating a subject matter index, the DCJS could set up rules and regulations for how the subject matter index would be applied. I have no problem with Gallo versus Pataki. I do have a problem with the fact that you left out of the analysis the key component.
But how does that explain partial match? Because there's no executive order with regard to partial match.
You know, I think that partial match probably could have been challenged on those grounds, although there was case law which seemed to indicate that because the intention in making the match, the sought-after match between the unknown piece of evidence and the DNA database, it was as a result of seeking that match that was thrown out a series of partial match DNA suspects. And so it was a byproduct of attempting to do a valid search under the 1994 and 2006 amendments to the DNA Act, and by the way, the Memorandum of Understanding between DCJS and the FBI. So, in all of those things, you're 100% right. You can operate, and this commission can operate, does operate, and has, and within its powers, in fact, under 995, it has the powers to set forth all these rules and regulations, provided that there's either a statutory authority at 995A, B, C, D, or there's an NYCRR. Gallo versus Pataki does not help you. It just doesn't. Because if it did, we wouldn't have had the order from the governor. But let me put that aside for a moment. To your knowledge, has this commission or DCJS ever taken a position that 995D does not allow for any kind of comparison to the DNA database unless it's a match? Has that ever happened? We've taken that position in DCJS under your stewardship.
I'm going to use a phrase that lawyers usually use with me.
Right.
With all due respect.
It's a bad phrase. When I use that phrase, it has a whole different meaning.
I don't know about that. When you analyze statutory power, an executive order or a regulation cannot amplify or change what the statute allows. The statute is the statute. All an executive order does, or a regulation, is explain the meaning of the statute. The statute either gives us the power or it doesn't give us the power. An executive order issued by the executive, no matter whether we have the President of the United States or the governor or anything, they can't change the power that the legislature has conferred through the statute. All it can do is something like what we were talking about before, lay out what the application should consist of. That executive order may allow certain things, but it doesn't give any more power than the statute gave. So what that case is essentially saying is that the statute confers the power to do what was allowed under Gallo. And the executive order could only be valid if it's allowed by the statute. So you have to go back to the statute, period.
Well, let me.
And that's what Gallo does. I've read the case. That's what it does.
Yeah, I've got the language in front of me, Marvin.
Yes, I have it
If you
too.
look at the language, it's exactly consistent with what the judge just said. The last sentence of that paragraph dealing with this doesn't say because the executive issued an order. It says the court finds the creation of the subject indexes
Where are you
within the
reading
authority.
from? I just so
I don't have page numbers on it, but as I read Gallo, it's very clear the court was upholding the commission and DCCS's exercise of authority in creating the subject matter index with or without the executive order. But again, I think we're at a point, I think we have differing opinions, which is absolutely fine. I think that's the beauty of making for this commission. If you've expressed yours, other people have expressed theirs. If you have a motion you want to make or something based on that, I think it's time to do it.
I will have one more point that I want to make along the lines of the questions I asked you. In fact, DCJS did take a position that familial searching was not permitted under the statute, and that you could not make a request of any kind to go from an unknown sample all the way up into the database to look for a familial match. And that occurred in 2010 in a case called People of the State of New York versus Selwyn Days, D-A-Y-S. You're familiar with that case, I know, because under your stewardship. And
I actually was not here in 2010.
oh, okay. Then maybe you don't know that.
It only
Ms.
seems
Bianchi
like
knows
it's been
about
that long, Mark.
Council knows about it, because it was Ms. Bianchi's affidavits throughout that case that were relied upon by the court. I have the affidavits here. They were Ms. Bianchi put in an affidavit in opposition to a motion for issuance of a subpoena ducis tecum. So the problem was there was a trial. There was DNA found in a mixture on a bike. The defense attorney asked for what's called a keyboard search or a checkboard search. It was done. I think it was done by the Westchester lab under Bob Adamo and a woman named Mary Eustace. I may be pronouncing that incorrectly. And I don't have the exact numbers, but they found 263 possibilities. They eliminated 200 right away as no relevance whatsoever. And that left 63. And of the 63, they initially said in their letter that 63 possible matches. They then did more studying on that, and they found no forensic hit, no match. And so the default position was it was no match. So they had in the same letter potential match, possible match, and no match. And there was a fight between the defense and the prosecution over what the hell that meant, and it was fought out back and forth. But what was amazing was the position taken by DCJS. And that position was the defense could not ask for familial searching, because that's what the defense made a mistake in that case. They conflated familial searching with partial match searching. And the prosecution did a good job of saying, we have partial match, it's permitted. But that's not what the defense is seeking. The defense is seeking familial searching. And so to make sure that the defense could not win that case, which is the right of the prosecution, they sought out Ms. Bianchi's help and that of the DCJS. And in that case, it was Ms. Bianchi's affidavit that won the day, because she was the one who wrote that the defendant's request for identifying information pertaining to offenders in the SDIS who were found to be a non-match is simply a fishing expedition for investigative purposes for information pertaining to individuals who have not been shown to have any connection to the crime scene since there was no match. To release names of those who have not been found to be a match is strictly prohibited by the strict confidentiality provisions of Article 49B. She went on to say in her affidavit, what defense counsel seeks here is more akin to familial searching, though he is likely not seeking a family member. That was their opinion. Moreover, despite his statement regarding a DCJS policy on familial searches that I helped create, Ms. Bianchi saying that I helped create, no such policy exists in New York. To my knowledge, only Colorado and California have familial search policies. England does as well. I believe all such searches are strictly regulated. In any event, the New York State Commission on Forensic Science declined to consider a familial search policy and only after years of consideration implemented a limited partial match policy. The policy does not permit actively searching or trolling the database to attain a genetic linkage to a specific forensic profile, which is a familial search.
That's true.
Miss-
The partial match, the
Miss-
partial match policy does not permit that.
Right.
That's what
Mi-
we're here to consider.
This affidavit, and one adopted by Mr. or Ms. Deanne Kerr McCullough.
I guess, what's your
We're
point,
adopted.
Darvin? I
So my
don't think
point is-
anyone doubts that in 2010, there was no policy or regulations adopted by the commission allowing familial search, and whether a prosecutor or a defense attorney came to DCJS and said, please do this, I would have hoped to God the answer would have been no, because we don't have policy. The question on the table now is, should we adopt a policy allowing it?
The reason then given was there was no statute. And to answer
No,
you,
say
that's
that.
not-
That's not what that
There's no
affidavit
policy.
said,
to-
not what I heard you read.
That's not what I said. It's
Let me
under
just-
the
That's not what you
policy.
read, Marvin.
that's how I read it.
Wait a
That's how I read
minute.
it.
Okay, then, what I heard you read was that Ms. Bianchi said there was nothing in the policy. She made no reference to whether or not the statutes empowered the policy or a change in the policy. You just read, what she said was that there was no policy, which I believe is an accurate statement.
At the time, there wasn't.
Let me,
There still isn't.
let me go back. Let me go back to Deanne Kerr McCullough's affidavit, paragraph 22, page 8 of her affidavit.
Who is,
Deanne Kerr McCullough is an attorney, is attorney general in Eric Schneiderman's office.
so she was the prosecutor?
I don't think so. I think this was a local Westchester case, and when the issue was joined, they brought in the AG and through the DCJS to contest. Yes, that's what I think happened. So in McCullough's affidavit, under part 3, starting at paragraph 21, entitled Familial Searching, she too says, there's a very significant difference between familial searches and the release of information after a partial match pursuant to NYCRR 6192.3. Familial DNA profile searching is a data mining technique in which uses specific software algorithms to intentionally trawl offenders' databases for relatives of the person who left evidence at a crime scene. This technique is described as familial searching because the siblings, parents, or children of persons in the DNA database may share more alleles. And they refer to an affidavit by Duisman. New York does not authorize the use of familial searches as described above. Continuing on, I'm skipping paragraphs, I go to paragraph 26. Since DCGS has no policy on familial searches, because they are not authorized by any statute or applicable regulation, close paren, any claim that the existence of a familial search policy in New York in any way supports the defendant's argument must fail. And they cite to Duisman's affidavit. So clearly, what Deanne Kerr-McCullough was talking about was there could be no familial policy back then because they were not authorized by statute or applicable regulation. And by the way,
I read that language
when
differently,
you said,
Margaret.
Judge,
I don't read that.
well,
She says,
when
or,
you
they were
said,
not
Judge-
authorized by statute or regulation.
right.
And what we're debating now is whether or not we should adopt a regulation authorizing that.
But
secondly-
we don't
Not
adopt
adopt
regulations.
Her
We don't make
opinion-
regulations. We can only
I
make
should say
policies.
policy.
Only the
And
state
then there was-
legislature can make a regulation.
No, that's
No,
not
no,
correct. That's
legislature
not
doesn't
true.
make
Yeah,
regulations.
regulate.
The agencies make
Yes.
regulations.
That if we adopt a policy, there will then be the regulatory process
Right.
will be put in place. And if the reg ultimately gets adopted, then it will be allowed. But all that aside, her opinion in 2010, I don't really see as relevant. But secondly, if you read that language, I read that language to say there's not a statute and then there's an or in there, or there's not a regulation.
Right.
What we're debating is should we adopt a policy and based on that, go through the process to get a regulation adopted to allow it. So
Okay,
I just don't see what that
So
is.
where we disagree then is simply my belief that 995, as currently written, which is the basis for this commission, does not give power to this commission to do that, nor does it give you as commissioner the powers that we were talking about initially to make rules and rulings on applications from law enforcement. Judge Mazzarelli, I would only say to you, I don't know where in 995D there's any authorization for this commission to make use of the database, not for the purposes of a match or a partial match, but simply to use the database to pursue investigative leads. I don't see it anywhere in 995. Without it, I don't think this commission can.
I think you've made your point more than clear and you've done it very eloquently. So thank you. Bill?
Can I get a copy of that last statement?
Absolutely. I'll put it in a letter and send it out.
Marvin's perfectly free to correct me if I misstate his position, but I'm reading from page 44, which is his letter. I don't know how many pages the letter is, but the essential argument from the Commissioner Marvin is that, and I'm reading, this statutory scheme does not authorize or even contain a provision by which the commission or the subcommittee can delegate its powers to the commissioner. And that argument is premised on the first two sentences of the same paragraph where Marvin says, where the legislature wanted the commissioner to have specific powers, it was specifically mandated. And he gives as an example 995B11, the commissioner, upon a recommendation for the subcommittee, must designate one or more approved methodologies. That's actually incorrect. 995B11 refers to the commission, not the commissioner. So the whole argument is premised upon a mistake, namely that for the commissioner to have powers, they must be statutorily delegated. In fact, the opposite is true. The commission has tremendous powers to, and I'm quoting here from 995B, the commission shall promulgate a policy. The commission shall designate one or more approved methodologies. The commission shall promulgate standards, and so forth and so on.
Right.
995 is replete with references like that. If we want to adopt a policy, if we want to adopt standards, we can delegate authority to the commissioner or anyone else if we so choose. That's within our powers. And your powers, Commissioner Green, are delegated or are outlined in Executive Law 836. And if you look at 836 subdivision 5, it gives you very broad powers in terms of sharing data, collecting information, so forth and so on. I think that this 995 couldn't possibly have anticipated YSTR analysis, mitochondrial DNA analysis, star mix, probabilistic genotype, and yet we have those, don't we? The statute doesn't have to be amended every time some new investigative technique comes along. So that's my response. I think you're well within your authority, and we are certainly within our authority in designating this policy.
Ann?
This is a procedural question. You've indicated that, clarification, if the policy is a recommended, binding recommendation from the DNA committee, comes to the commission approves the policy, it is your intent that the division will submit regulatory language?
The regulatory language, I believe, is
It's in here.
included in here, yes.
And the implementation of the new policy cannot proceed until that regulation is formally adopted?
Correct. It's not
Through the
going to
usual publication,
Regulatory
public
process.
comment, response
Yes.
to public comment, so we may still be months?
Yes.
All right, that was just
Is
procedural
it a
clarification.
45-day period
be public comment period. yes.
Initial,
Generally, yes.
from starting when?
when it's
From-
published, and it has to go through Department of State. Fine, thank you.
All right, any other comment or discussion? And if not, do I have a motion to adopt the, I guess, should we do the policy separate? All right, so do I have a motion to accept the binding recommendation from the DNA subcommittee with regard to the state familial search policy, along with the corresponding changes to the regulations and DNA implementation plan?
So moved.
All right, do I have a second? I have a second. All right, any further discussion? All in favor?
Aye.
Anyone opposed? All right, and any abstentions? All right, thank you. Why don't we take just a 2 or 3 minute break? Mainly because I have to go to bed.
Is all this on air? No.
In the 45-day period.
I don't have control over it. Sorry.
No.
Sure. How are you? Good to see you. I fix it. But it isn't. Not your personal. No, that's fine. Hey.
Oh, wait. No. Oh, I was looking at a different page. Never mind.
No.
I was looking at the middle. I was Yeah, that's exactly what I did.
So I guess.
Like this is like this direction stuff, you know, where the first one we have to.
Rachel's never. She went upstate to the lecture for the New York prosecutors training institute this week. So, and then
It's so funny to do that like a total
Never carried.
I saw Luke yesterday.
Oh, yeah.
When you need it, I got like $3 in my wallet. I was always using my ATM
And
card.
then I saw Gabby. Her time kept getting saying that she did not. Sorry.
No worries. No worries.
Because I was like,
Yeah, it's true. I never thought about that.
Similar. Very good. So it's just not. I'm just. Never I would call the office. Give me your phone. The stuff that they gave me was just the same
Yeah, it is. I normally like it as cold as you can get it, even I think it's cold in here.
Would you like my jacket?
No,
I was
no.
gonna say, someone took my jacket.
I think we should tell them to turn it down.
I
a
did
little.
actually. I went out and
Turn it up, you mean?
Well, you know, make whatever, however you want to describe
I
it.
think there's a certain person that likes to see this.
You know, Brian.
That's the only thing I like about it.
That chart that you compiled is very helpful.
Okay.
And very concerning. There's some very concerning things in it too.
Okay.
You know, which really go to the ability of council to challenge
Right.
this stuff.
You do your homework.
Make it easier.
They teach us that in law school.
What?
I said they teach us that in law school.
That's
Do your
right.
homework. God, his birthday, better text her.
Hey, Greg, can you start assembling people?
Yeah.
We start assembling people from outside and tell them we're starting?
He knows it all, so he's this is what
Jerry, I thought he last night we saw great Josh Wilson. Yeah, I need to sort of research. I think it's based on one clip, which I know. But he is great See, Karen went yesterday.
Or that's just how it is. Oh, yes, they
How could I possibly vote?
Yeah,
But
it looks like it's better. I didn't see Scott.
So theoretically, you could do a web. Have you found out what the problem is?
This wasn't working well.
Are you actually live streaming?
Yeah. Not anyone else was
But we could have.
Yeah.
So that's the problem?
Yeah.
Not the computer?
Yeah. It could be either.
Well, if you're doing it now, it's not.
Well, I mean, I don't know. It's what expert here.
It's their computer? But our computer.
It's our computer, but it's the one from the ITS guy.
Thank you, Jackie. I'm sorry to do that. You just get everyone in their seats, tell them we're starting, tell Marvin and
Oh, the only thing we were out of was receipt, but it didn't come in.
Okay,
Do you want
thank
something
you.
different? No, okay.
Probably better for them. Thank
They
you.
tried on theirs, so it's on this end of the camera.
See what?
They tried to adjust the camera
Okay,
on
that is what it is. Fine with me. Thank you though for trying.
I said, I think the commission does a great job. I said, what are they? I think we should figure it out. And I said,
All right, let's try and get going.
Something told me else about
All right, let's get started again.
I was like, I thought it was something, but
Marvin.
I move your credit all these matters.
I second.
Where's Scott? Where's Scott? Do we need to turn it on again, or is it going? Okay.
And it has nothing to do with
My namesake, first name.
All right, let's get started again if we can.
When there's work to be done, I look to you. That's all.
Do we need to wait for the recording, or are we all set? All right, we're back in session. The next item we have on the agenda relates to validation. We have a letter that is in your materials, I believe on page 55, from Dwight Adams, the chair of the DNA subcommittee, to me, I guess, to the commission also. I'm indicating that at the May 19th meeting of the DNA subcommittee, the subcommittee reviewed the New York State Police validation of the Denver familial DNA searching software version 2.1N. After a thorough review, presentation, and discussion of the documentation provided, the subcommittee unanimously voted to issue a binding recommendation to the commission to approve the use of the Denver software for familial DNA searching in New York State. The vote was to approve the software as described in the final approved policy, and then he goes on to spell out the established kinship thresholds that they are approving. So that's in front of us now in the form of a binding recommendation. Any discussion or questions with regard to that binding recommendation? Yeah.
Is it our understanding then that the only familial searching that can be conducted in New York State will be conducted through the state database and by the method validated by the state police lab? That no local lab will conduct familial searching in their local database?
As I read our policy and the corresponding regulation and plan that we approve, it is limited solely to the searching that you just described. It does not authorize familial searching in any other database. Now, whether somebody else feels they have the authority from somewhere else to do searches in those or not, I don't know that we are specifically addressing. But in terms of what we have approved and would be approving, as I read it, it is limited as you just described.
My second is just a comment. Validation documents are voluminous. The data that goes into them is voluminous. We all know we've worked in laboratories. To distill the conclusions of the review of that database basically to one sentence, there's no opportunity then, and I didn't attend the meeting, and I could have attended the meeting, but the importance of availability of the background documentation that's in support of that conclusion. The laboratory has it, and we've heard that they have it, that they keep it, that they would have it. It was presented to the subcommittee. Does the subcommittee keep it as a part of its record, as a part of its?
Yes, those documents are archived. The
So
executive summary of that document was also posted on the open public web for everyone to review.
So those documents would be available from DCJS, the Office of Forensic Science, as well as from the laboratory that submitted them, right?
Office of Forensic Services.
Yeah.
When you say available, they're there.
Under FOIL, could an individual ask for the copy?
And that would be something, if we got a FOIL request, it would go to our legal department, and they would analyze the FOIL statute and make determination.
Would you,
We're obviously going to keep them, we're not going to alter them.
Yeah,
and
I know.
if we are compelled or obligated to turn them over under some instance, we certainly would.
This very specific question then, were those documents marked as proprietary and therefore subject to possible redaction?
I think when you say proprietary, I'm not a lawyer, but
Well, either the laboratory submitting their validation documents, as they often do to the health department, will mark them as proprietary. They are data potentially useful for intellectual property claims, business value claims, business plan, and so they will mark them as proprietary, so that when they are requested under FOIL by a competitor or for some other purpose, then the submitter, the laboratory that submits them, has to be asked for their justification of why they believe they should not be disclosed, and if they can document legitimate business interest or other, all those rules that give us that we don't release under FOIL, they end up being redacted. If not, the validation document can. Now, we find in clinical lab world that most competitors won't ask because they don't want somebody to ask for theirs. Quid pro quo kind of thing. But in the court system, I think we might anticipate a different circumstance. It's not a competitor, it's not even a science, it's the expert testimony.
Yeah, I don't know how they were marked, but if we received a request for those documents, those would be issues that
You
we
would be
have to
deal with it in a normal course of a FOIL request.
And to the first part of your, I think, comment, yes, we have limited information in front of us, but I guess, one way I look at this is that the DNA subcommittee, was created for a purpose, in a role, and to some extent, as I see the scheme, there are certain things which we should be relying on their expertise for. And I did attend the meeting, and it was obvious from the meeting that I believe there were 5 DNA subcommittee members there. It was obvious that they had taken a great deal of time to go through this. The presentation and discussion lasted, I believe, for over an hour with regard to this particular matter. So yes, what we have in front of us is limited, but as I understand the scheme, to a large extent, there are certain things that we have to rely on them for, and this is one of them.
I just wanted to make a comment that I was at the subcommittee meeting, and I was impressed by the presentation of the validation of the software. So as from a scientific standpoint, I did think that it was a thorough a vetting of the software that's going to be used for these purposes.
In any case, those records that were produced became records of the commission.
Of the DNA subcommittee.
Which is a subcommittee of the commission.
Yeah, I don't think we need to decide that now. It was the DNA subcommittee, certainly their records, whether they're the commission records or not. Pat, did you have something?
No, sir.
Okay. All right, if there's no further discussion, do I have a motion to accept the binding recommendation from the DNA subcommittee to approve the use of the Denver software for familial DNA searching in New York as described in the final approved policy with an established kinship threshold of log of likelihood ratio equal to 3.7 and then parentheses likelihood ratio of 5,000 end of parentheses for profiler plus / co-filer log of likelihood ratio equals 4.0 parentheses likelihood ratio of 10,000 end of parentheses. And to the extent that I have not read that right, it'd probably be more accurate for me to say as set out in the letter of May 30th of 2017 from Dwight Adams to myself, contained on page 55 of the materials that everyone received for the meeting.
So moved.
All right, do I have a second?
Second.
All right. Any further discussion? All in favor? Anyone opposed? Any abstentions? The next item we have is accreditation and laboratory updates. Brian, do you want to take us through these?
Sure. The first item we have is the Nassau County Toxicology Laboratory. They went through their external ABFT inspection. The documents are in their binder. We have management from that laboratory here. If there's any questions, there is a vote required. So if there's no questions, do I have a motion to renew the New York State accreditation of the Nassau County Medical Examiner's Forensic Toxicology Laboratory for the period covering July 1st, 2017 to June 30th, 2019?
Motion.
I'd second it.
Okay, so we have a motion. Who made the motion? I'm sorry. So do we have a second?
I second it.
All right, all in favor? Anyone opposed?
Okay. Similarly, the next laboratory is the New York City Office of Chief Medical Examiner Forensic Toxicology Laboratory. They had an external evaluation. A vote is required. We have the director of that laboratory here. If there's any questions, and documents are in your binder, starting on page 105.
Any questions for the lab? All right, if there are no questions, do I have a motion to renew the New York State accreditation for the New York City Office of the Chief Medical Examiner's Toxicology Laboratory for the period from July 1st, 2017 to June 30th, 2019? All right, do I have a second?
I second.
All right, all in favor? Anyone opposed?
I'm abstaining.
And one abstention. Thank you.
Next laboratory is the Onondaga County Health Department Medical Examiner's Office Forensic Toxicology Laboratory. Similarly, they had an ABFT external, and again, this will require a vote. We have the director of that laboratory here in New York City if there's any questions. And the documents are in your binder starting on page 185. Does anyone have a motion to renew the New York State accreditation of the Onondaga County Health Department Medical Examiner's Office of Forensic Toxicology for the period covering July 1st, 2017 to June 30th, 2019?
So moved.
We have a second.
Second.
All right, all in favor? Anyone opposed? And any abstentions?
Next laboratory is the Westchester County Department of Laboratories and Research, Division of Forensic Toxicology. It's the last vote we have regarding the external evaluations, and we have Ms. Spratt here to answer any questions. I actually have some questions. I don't know if others do as well. So I guess there's a whole bunch of specific ones, but I know there were several issues that were identified in the external evaluation, and ABFT has accepted your suggestions for fixing them. I was just wondering how far along we are to fixing them.
We're almost finished. The hardest part is linking the older data to the summaries we had in place. So Chris Corling is my quality assurance person. He's working on finish all of them, and he's got everything linked. So our goal is to be finished by the end of this month, beginning of July.
Okay. Some of the things had to do with like validation work, and I was just wondering if that is done yet or if that's still in progress.
That's in progress. The reason it's so slow is because the LCMS is new and we're learning the newer software. So trying to get everything completed and then get everything finished. We're having trouble with the reports. That's our biggest problem. So not being able to print things has held us back. So we're doing some other work in order to move on, but that will be finished. We got our last fix 2 days ago. So we're hoping that program will work, and then we can go ahead and finish the validation that's required.
Are there other things that are still holding over that need to get resolved, or is it just the validation stuff at this point?
If we've done all the standard controls, we have to do some matrix matching as we do. What our goal is to put several different drugs together in big groups, and so that's going to take us a while to find the positive samples and then validate and do the matrix matching. So that's on the newer stuff, which we've just started. The first test we did was acetaminophen. It was a one-drug test we were doing, same extraction, better sensitivity with the LCMS. So the holdup was because we couldn't get everything matched, and we were asked to do additional work on that validation. So that's what's taking. It's not taking a while. It's just we don't want to do it and not be able to print it. That's our bigger problem. So that's what's holding it back. But we have that plan in place, and it's going to be done hopefully by the end of this month once they do the last fix.
But you're physically doing the analysis now, right?
Well, we don't do very many of them, but that was the easiest one we thought we could do. So we haven't done maybe 5 cases at the most. And we've taken cases that aren't really called toxic. We just wanted to make sure that we could get the data and it was working correctly.
Can I just ask you, by September, I think our next meeting is in September, but by September, do you anticipate that a lot of these things would be done?
Oh, absolutely. I think they're going to be done sooner.
All right.
And our goal is to have them done sooner, but September is definitely they will be finished.
I guess my lay reading of this is that they made some findings, that you have a plan in place to address all of them, that you're addressing them, and by September you anticipate that they would all be addressed.
And yes, and it's also an ongoing validation because as we bring the newer drug panels together, we'll have to be validating in the same way. So that takes a lot more time, but our goal for what we've requested that we do will be complete hopefully in a couple of weeks once we get that last piece of the software working. And then when we do every single panel, we'll do the same type of validation.
All right. And we do need a vote for accreditation, is that correct?
Yes.
I guess what I would suggest, I would be more comfortable if we would extend the accreditation until September. Just have you come in September and update us in terms of where you are with everything, and then take a final vote in September.
The September meeting is during the soft meeting, Society of Forensic Toxicologists, so my plan is to be there. I can send my quality assurance person if you would like.
I don't see any reason why that wouldn't work.
Okay.
I don't know, does that sound reasonable to other people on the commission?
Yes.
Yeah.
Mm-hmm.
All right, so then what I would do is make a motion that we extend the New York State accreditation for the Westchester County Department of Laboratories and Research Division of the Forensic Toxicology for a period lasting until the next meeting of the Commission on Forensic Science. So just in the event that something happened and we weren't able to meet in September, it doesn't run out. And then at the next meeting, you will get an update and hopefully take a final vote. So do I have a second for that motion? All right, all in favor? And anyone opposed? Any abstentions? Thank you, appreciate the report and the work.
Next laboratory is the DCGS Latent Print Laboratory. They have a change in their quality assurance manager. The director of that laboratory is available via phone if there's any questions. Or actually in Albany, I believe. Okay. Next laboratory after that is the Erie County Department of Central Police Services. They have a off-site surveillance visit review. They also have some changes in management with a new lab director and a new quality assurance manager. The documents there start on page 309 in your binders, and we have members of the laboratory available if there's any questions. Next laboratory is the Erie County Medical Examiner's Forensic Toxicology Laboratory. They have a mid-cycle review they did, and I actually have a couple of questions, and I believe the laboratory director is available via phone.
Hi, Christine. This is Shelley at the commission meeting. You're on the commission number. Thank you very much.
Hey, Christine, it's Brian Gestring. Just a couple of quick questions. So we have the mid-cycle that we have, and for commission members, starts on page 318. So last year, I believe it was actually a year ago in April, you had the external evaluation and had found some issues.
Yes.
Are all the issues that were identified in the external all resolved now?
Yes, they are. We put the plan in place that we had documented last time, and we've got the fall tracks operational and the other pieces that I had outlined at that point in place.
Okay. I'm just trying to see, so you've done the quality review of the manual for this year?
Yes.
And all the calibrations and QC material not from the same stock solution?
Yes, we purchased external controls from Sterling and updated the SOP to reflect that, so they are now from a different source.
Mm-hmm.
Did you want me to go line by line?
No, I'm just trying to think of the bigger ones just that we were going through.
Yep.
Okay, so that's just what I have for now.
Okay.
Anyone else have any questions? All right, thank you very much.
Thank you very much.
Yep. Next laboratory is the Monroe County Office of the Chief Medical Examiner Forensic Toxicology Laboratory. So they've done a self-evaluation summary that was reviewed by ABFT. They're also have some changes in management, both the quality assurance manager and the lab director. So if there's any questions, we have lab management available. If there's anything you want to add?
So in the first paragraph.
Page 323?
Yes. It says in 2016 we plan to replace. Is that a typo? Or is that 2017?
Actually, do we have, hey Kathy, do we have Dr. Hartman, or is she on the phone?
And I was also wondering if there's any particular reason why a third of their lab personnel is.
Yeah. How would they survive?
Hi, you've reached Rebecca's cell phone. I'm not available.
So maybe what we can do is text her and then revisit that if we move on. You okay just putting that on hold for the moment?
Sure.
Just putting Monroe County on hold for the moment, maybe if we can just shoot her a quick text. Niagara County Sheriff's Department Forensic Laboratory. We have a change in management. That's over there. And again, documents are in your binder, page 335. And we have management available if there's any questions.
Just as a point of clarification, when there's a report that there's top management change in a lab, does your office review their credentials to see if
The commission actually has a copy in the papers in front of you. You have the documents there. The New York State and the external bodies, New York State doesn't have any specific guidelines. The external bodies, either ABFT or ANAB ASCOT Lab, have their own way to evaluate them.
And that's done at the time of the change as
Yeah.
opposed to the next
Yes.
cycle? Okay.
The last thing under the accreditation items is the annual lab summary. This is just a summary of the documents that are exchanged between the laboratories and my office, and this is provided every year.
Didn't we skip something?
What are you talking
Oh,
about,
I jumped over Westchester, I'm sorry.
Westchester County?
Yep, Westchester. So, sorry about that. So Westchester County Division of Forensic Services, they have their laboratory went on off-site surveillance visit. Page 335 of your binder.
I'm just curious, did this off-site surveillance report, this was conducted by ANAB?
Correct. ANAB ASCLD Lab, the entity, because you can see on the bottom, if you look on page 335, ANAB is on the top, and on the bottom it also talks about ASCLD Lab. It's got the symbol on there. But that'll be a natural segue actually into our next topic if you want to.
But by off-site, we mean they don't actually visit the lab.
They don't.
Review documents
Exactly.
self-prepared by the lab, submitted to the.
All right, so I think that takes us to, takes us back to old business again. We were in the process of evaluating different external accreditation bodies that could provide forensic lab accreditation services in New York State. One of the things, in addition to just all the other work that we had on our plate that delayed this, was the ASCLD Lab, ANAB, and I use merger loosely. I don't want to, I know there's been some discussion about what the relationship is, so I don't want to get into the middle of that. But we did provide ANAB, ASCLD Lab, with feedback with regard to some of their proposed changes to their supplemental standards at our December 2016 meeting. The standards have now been finalized. There's a copy of the new standards in your binder starting on page 389. And we do have a representative from ANAB, ASCLD Lab here today to answer questions that the commission members may have. The Office of Forensic Services did also put together a two-page summary table, which is in your materials as well, that hopefully will be of assistance as you look at these issues. And I just, as a caution, the summary table is not meant to point out every single change. It just highlights the changes that we felt were important, which may or may not be the same as, what other folks here feel is important. So hopefully you find them helpful, and thank you to Brian and your staff for preparing those. So with that, who do we have here from ANAB, ASCLD Lab?
We have Pam Sale, Vice President.
So Pam, maybe if you, do we have a seat at the table there? So maybe if you want to just introduce yourself, and if there's anything you want to say by means of introduction, please feel free, and then we'll open it up to questions that commission members may have.
Okay, I'm Pam Sale. I'm the Vice President of Forensics for ANAB. Previously, I was the Executive Director for ASCLD Lab. I worked as an employee of ASCLD Lab. I started in 2013. Prior to that, I was at the Oregon State Willys Forensic Lab for 19 and a half years. I don't know. I might just be good to go into questions. I know there were. I have listened to the last two commission meetings, so I do know the topics that you brought up. I appreciated getting the letter and directing me to where I needed to listen to that meeting so that we could address those comments when we revise the requirements. And I think we addressed those issues, but certainly if they're still there, happy to explain why we made the decision that we did.
Well, thank you for coming. We appreciate your being here and your willingness to engage in the dialogue. With that, Marvin?
So I have a question for Pam, which, just by way of disclosure, I've discussed with her. And she knows this question is coming. I've discussed it here at this meeting. And it concerns what is the entity that we're dealing with. Is ANAB separate organization? Does ASCLD Lab still exist? As I understood it, I've put it several times here, but we need a definitive answer. As I understand it, ASCLD Lab has ceased to exist. It does not exist as an entity anymore. It has, its prior board has been absorbed as a special advisory board to ANAM. I may be wrong about that. But the legal entity that's now conducting the accreditations is ANAM, a separate group entity by itself. Is that correct?
Mostly. So, yes, it is correct that ANAB is the legal entity. As ANAB assumed all of the assets and liabilities of ASCLD Lab on April 22nd, 2016, that included the ASCLD Lab name, logo, the entire accreditation program as a whole, and all of the ASCLD Lab staff. So the same program with the same set of requirements and the same people running it are still there, but the legal entity is ANAB, the ASU National Accreditation Board. ASCLD Lab no longer exists as a nonprofit company on its own. The legal entity has been dissolved.
So, of course, referring to you as ANAB ASCLD Lab is not correct. You are ANAB.
We are ANAB. Because of the merger, we have multiple accreditation programs running right now. So we've gone through the requirements, or what you commented on the merged program. But the ANAB ASCLD Lab, as Brian refers to us, he's referring to the accreditation program that exists for all of the ASCLD Lab customers. They're still accredited to that program, to that set of requirements. Their accreditation certificates and scopes of accreditation did not become null and void because of the merger. So the program still exists, but the company ASCLD Lab does not exist.
Is the accreditations that you're doing now as ANAB, do they include the new rules that have been subsumed by you and changed?
So the assessments that we're conducting right now, as of June 1st, could lead to different sets of requirements depending on what the laboratory chooses. So everybody who is accredited to the ASCLD Lab international requirements can still move forward with us assessing them, reassessing them to those particular requirements through the end of December 2018. So we are not forcing labs to transition right away. They get a period of time to make that transition to those changes. Same with the former, the laboratories that were accredited under the ANAB program. They have that same transition timeline to move forward to get in conformance with those merged requirements. Laboratories have the option of telling us, when you come in and do my reassessment, or when you come in and you do my surveillance visit, I would like you to be assessing me to the new set of requirements. So there's options right now.
I have two more questions, and then I didn't see this on the spreadsheet that was prepared by the Office of Forensic Services, but my question is this. Under the new ANAB rules, which apparently by December 2018, that's going to be what we're going to be using, assuming that ANAB is the organization that we go with. Who is the customer? How do you define the customer for forensic services?
We actually have a definition of customer in the document itself, 3.8. It says a person or organization that could or does receive a product or service that is intended for or required by this person or organization. A customer can be internal or external to the organization. As we have used customer...
It's on 392.
As we have used customer in the requirements document itself, it's referring to customer communications and notifying the customer of certain things, database searches and things like that. More referring to the customer as the entity that submitted the evidence to the laboratory, the attorneys that are using that information. So the customer and the customer's customer, when we're talking about communications, anybody who's going to be using that report needs to understand what it means.
And the last question, let's assume we settle on whatever the new rules are that come about as a result of the comparison of Asplat Labs old rules and your rules. Will all of those rules be now published online, open to the public, to attorneys, newspapers, anybody who wants to read?
Our supplemental requirements, they're actually, for Asplat Lab, they were called supplemental requirements. For A&B, they were called accreditation requirements. They are now in a document titled accreditation requirements, and that is available on the A&B website for anybody to go to. The only thing you can't get there is going to be the international requirement, like ISO, IEC 17025. Those are that 17020. Those are copyrighted, so clearly we can't post them there. But our requirements are posted for anybody who wants to see them.
So I have no further questions. I don't know if it's appropriate. Other commissioners may have questions to bring up this issue I've spoken about in the past. But who the legal entity is, what does that mean for the commission, which by law must designate an outside accrediting agency? I'll go with whichever way you want to do this.
Let's take all the questions first. So anyone else in the commission? Ann?
This is sort of a shortcut question. So, what is your view of the changes, the implications of the changes? Are they more stringent? Are they less stringent? And you can go one by one. No, I mean, what's the advantage to the laboratories? What's the advantage to agencies that rely on the accreditation coming out of your organization? What might be the pitfalls?
Okay, so I think the requirements are improved. Of course, we would put out a document that we didn't think was improving upon the previous. What we had done when we went through it is to go through the requirements and say, is this adding value? Is this adding quality to the laboratory system? And one of the things we're looking at is, are we prescribing how it has to be done? Instead of what needs to be done, but are we telling the labs how they have to do it? So I think one of the benefits to the labs is that we've added some flexibility. We tried to take out language that said, you have to do it this way, and said, this is what you have to accomplish. This is the requirement itself, and giving the labs options on how to get there. So there's more than one way to load the dishwasher. I do it a different way than my husband does it. The dishes get clean regardless of which way we get there. So we're giving that flexibility. We also wanted to make sure that the requirements were no longer specific to hard copy paperwork. So we have stuff like you have to have a handwritten initial. It's hard to put a handwritten initial if you're doing everything electronically. And so what we did was we took, what is the intent of this requirement? The intent is that you be able to track back which analyst did that part of the work. So as long as the laboratory is meeting that requirement, you don't have to have the handwritten initial. So we took some of the language out that was prescribing specifically how something had to be accomplished, and rolled it back to a general language that would be more applicable to hard copy and electronic, and let the laboratory define the method of how they're going to get there.
So providing that flexibility puts some new burden on those who perform your inspections, because they have to make some kind of judgment that what the lab is now doing, if you're not asking for written document. But now what they're doing is meeting an intent when they have flexibility. How have you modified the training that you provide to your surveyors? Because I'm presuming you're still using volunteer participants in the field, And so they're leaving their own labs and going visiting the accredited lab. Is there formal training and what this flexibility means in terms of what they have to look for?
So there is formal update training that we're providing to our technical assessors. We also provided training to our lead assessors, and we did that in January and went through requirement. We went through those to make sure that they clearly understand them. While we're adding in flexibility, I don't think we're adding in an element of vagueness. So I think by reading the requirements, the assessors can easily understand what the intent behind them is, and we quite often, and for a very long time, have taught our assessors there's more than one way to do it. So don't think that the way you do it in your laboratory is necessarily the way somebody else has to do it. So it's not. I don't think it's a huge difference for them. A lot of the areas where we've added flexibility, we have language that says shall do something. We could say document, program. There are numerous words that we use that we've defined that means you have to put it in writing. So the laboratory defines how they're going to do it, and then the assessor can look at is that meeting the requirement, and then are they following this?
Have you encountered any problems of surveyors trying to survey using the new standards?
We haven't, because they were effective June 1st, and we have yet to have somebody go through an assessment under those requirements.
Do you anticipate, you've given the labs some time to consider the changes and how they're going to proceed after 2018? Do you anticipate any labs who won't meet the criteria?
Human nature, some labs are going to wait until December 31st of 2018 to tell us that they're in conformance with those requirements. We are requiring that they complete a specific checklist for us and send it to us when they believe they are in conformance with those requirements, so that on our next visit that we can go through those and ensure, even if it's not a full assessment on a surveillance visit or even an offsite, we'll go through and review certain items to ensure that they are actually in conformance. We'll have all that information when they submit that file as well. But they could potentially somebody not be in conformance by December 31st, 2018. Sure, I mean they could.
And they then lose their position.
And at that point, their accreditation may be sanctioned because they have not made that transition.
Will you have visited every lab by the end of 2018?
By the end of 2018.
To verify that whatever checklist they've sent you is actually.
We won't have visited every lab because our accreditation cycle includes the offsite reviews. And so it will be by the end of 2018 that we'll have been on site and reviewed and have reviewed every single
You're off. So
it might go every other
by
year.
what time? By what date will you have? If you're starting June 1st.
So potentially we could be in a laboratory in 2018, and they have not made that transition to the requirements yet when we're there. At the end of 2018, they tell us they've made that transition. In 2019, they may be scheduled for that offsite review. So it could be 2020 before we're actually on site again.
Those are kind of, high level questions, not in the weeds, but, trying to get it.
It's not going to like a completely new set of requirements either. I mean, most labs are going to be in conformance with the requirements as they are written right now.
It might be worthwhile to have a little bit of background, though, on kind of the evolution of this. And please correct me if you feel I misstated anything. When the ASCLD Lab program started, it was the first one forensic specific, so they created things very specific. When they migrated to the ISO, the international standard, they then created what they call their supplemental standard, saying this is what the testing and calibration international standard says, but we want this in addition to that. So my understanding of what happened, and also when you look at some of these things, it looks like there's a lot of changes and it's bad and whatever. It's not necessarily, because I think some of the things that are taken out from what we had in the ASCOD supplemental were things that are embodied in the ISO. So, and this is fairly granular. So just giving you an example, and I gave Pam a copy of this just at the beginning of this meeting. You guys got it last night, and I apologize for the last minute. It just took a long time to go through all this. But, and maybe this is a good segue to one of the first concerns I had, but it sounds like you addressed it, which is we had a concern about the lab director position being removed from the supplemental, from the accreditation requirement. So they left that in, but they took out the requirement for sufficient authority. And when I was talking to Pam just as she came in, she was saying that that's something that's covered within the ISO. So as long as the overarching lab is responsible for it, that is my concern, because to me, there's no stronger link to quality than having someone that we can call in, talk to, and have consistent communications with. So, and ultimately, even if the accreditation requirements from ASCOD Lab, ANAB ASCOD Lab, or from A2LA, or from ABFT don't meet our standards, we have the ability to set a New York specific standard to fill in any blanks or holes that we see. So I don't know if that helps for background and if you thought that was correct in a summary.
Sorry, Mom. Just Pam, because I'm just getting confused with all the timing that things are happening. 17025, which is the main body that we now have our new requirements, our accreditation requirements from ANAB, but 17025 is also going under changes. And I can't recall right now when they're supposed to be implemented, but have you seen those changes, and have you adopted your changes to be considerate to the sim? And again, it's like what comes first, so I'm just trying to work out, from your experience right now with 17025, like Brian says, it says authority in 17025, but has that been taken out of the new standard that they're going to be implementing in the coming years?
So I can't answer that question specifically. I have seen the new 17025 standard. It is not published yet. The international community has not had a final agreement on that, so it still needs to go to the final draft international standard stage, and it has not been released for that yet, to my knowledge. So it's still pending. But when we did the revisions to what were the supplemental requirements now called accreditation requirements, we took those changes into consideration. We took that new version at 17025, and we said, what we didn't want to do is make any changes to the accreditation requirements that would require you to put something in place that we knew as soon as that new standard came out would no longer be applicable. We didn't want to create extra work for them. So while certainly we're going to have to revise that again when that new standard comes out, because the numbering is completely different. And so we'll have to renumber our documents. I know it's a big sigh, but we feel your pain. We'll be going through the same thing that you'll be going through. We will have to renumber our document accordingly as well. But I think once that happens, it'll all get smoothed out. I don't expect that we're going to, make major changes to our requirements. We may have to revise the language so that it mirrors the language that's being used in that new version of 17025. But when that comes out, whether it be later this year, early next year, there will also be a transition period. And so we recognize that, yes, we're getting everybody to transition to this new set of accreditation requirements, and then we're going to ask you to transition to a new 17025. That will be down the road. We will not, it's not going to be like, oh, by the way, at the end of 2018, you need to be in conformance with the new 17025.
But we're going to be in this flux for a good number of years, right? And I think the point I want to bring up is, that flux is going to exist. You're going to come in and do an assessment of a laboratory. And I was just wondering, the technical assessors that you have, are those people who were ASCOD Lab technical assessors, who are now ANAB ASCOD Lab technical assessors, or is it technical assessors from ANAB? Like, if you understand my question.
So we are combining those assessor pools and providing update training to everyone. We have over 1,200 technical assessors in our assessor pool.
So this is where, some of the commissioners may get a little bit confused. There's a lead assessor and there's technical assessors. Technical assessors are volunteers from accredited laboratories, but a lead assessor is an employee, correct?
Our lead assessors used to be employees.
Okay.
And so our lead assessors now are all independent contractors.
Okay. And are those individuals a pool of ANAB and ASCLD Lab lead assessors, or still just mostly ASCLD Lab lead assessors?
It's fairly evenly split with the lead assessors right now. We still have some of the former ASCLD Lab staff assessors who have continued on as contractors. Many of them retired. They were retired from forensic labs. They worked for us for many, many years, and they decided that it was time for them to retire and enjoy retirement a bit. But we have
Nicely put.
people can enjoy retirement.
Yeah, I'm one of them.
But we had ASCLD Lab contract lead assessors as well at the same time, and so our contract lead assessors are now pooled together with the former A&AB contract lead assessors, and they're all just A&AB contract.
So these keep I'm sorry, but they're all leading on from a. So the point I'm trying to get, or not, I'm going to get there at some point, was so your lead assessors are going to be a mixture, your technical assessors are going to be a mixture, but they're going to be properly trained.
Yes.
Then they're going to come into an organisation. When they identify a non-conformance by ANAB, you've got a new policy where there has to be a root cause analysis. That's mandated now. But what I want to really get to is there used to be the board, the ASCLD Lab board, would sit and would see non-conformances come across their table, and as board, there'd be members of laboratory directors of accredited laboratories would sit and they would discuss the significance of that non-conformance, whether it led to that lab being designated having a non-conformance. Since the board no longer exists, is there an individual, yourself, or an entity that will be reviewing that, or is it now just left to the lead assessor? And the reason I'm asking, as a lab director, and even as a commission member, I have to be in front of my colleagues and I have to explain every single non-conformance I get. And now you're mandating I have to do a root cause for everyone. And I just want everyone to be aware that things have changed. So there may be more non-conformances coming across our desk. But it does not mean the quality of the work in New York State has decreased. I know your goal here is to improve, and we're going to try to improve with you. But we're also the board did used to give board interpretations. So when you do have flexibility with the standard, but you also have a way of getting it wrong, because you as a lab director interpret the standard a certain way, and you might not meet the interpretation of ANAB assessor or the board, and therefore you have a non-conformance. So I know that, as you said, you're not trying to tell people what to do, but sometimes lab directors like that. They like to be told what to do, because when we come on in front of the commission, and I'm not saying all the standards, Pat, so I know you shook your head there. I'm not saying in everything, but there's certain things that'd be like, how do I meet this standard? Because if I get a non-conformance, it looks like I'm not doing my job. Where I thought I met this standard doing my job this way, but you think I should meet the standard adding these other components to it. So, sorry that was a bit long, but...
That's okay. I think I got it all. So a couple of different things. One, we are in a no-win situation, because if we tell labs how to do it, they say, why are you telling me how to do it? Just tell me what needs to be done. But then when we stop telling them how to do it, they say, why don't you just tell me how to do it so I know how it needs to be done? So we don't, the board, and I didn't address this, Marvin had brought it up, the former ASCLD Lab Board of Directors, those individuals were moved over to what we have at A&AB called the Accreditation Council. So the accreditation, it's similar to what the ASCLD Lab Board of Directors was doing, with one major exception. That group is not making the accreditation decision themselves. So they do still deal with technical issues. If there's an appeal and it gets to that level, that group has technical expertise, and we put together a smaller committee of that group to hear that appeal. They provide us with input regarding operational impact of our potential changes, information technical changes. But as far as interpreting what the requirements mean, we had that full list of former ASCOD Lab board interpretations. Those got incorporated into the accreditation requirements themselves if we felt that they were valuable and needed to be there. Otherwise, they're going away. But as far as reviewing for consistency, because we do want consistency amongst our assessors and our lead assessors with the nonconformities that are being left with laboratories, our accreditation managers will be working with the lead assessors while the lead assessor is still on site. So we're kind of rolling back a little bit towards what ASCOD Lab used to do in the international program when it first started. Was we did this quality review with the lead before they left the laboratory. So we've been working with the leads, reach out to the accreditation managers while you're on site. Let's talk about the nonconformities to make sure that we're not having any issues, so that we're not leaving nonconformities that then need to be reviewed by accreditation managers after the fact and changes suggested. We want those suggested changes to happen whenever possible before the lead assessor leaves the laboratory. But in any case, our accreditation manager does review all of those reports, all of the nonconformities that come back in from the lead assessors, so that, you know, if there's any training issues that we can identify with, hey, the lead assessor is not understanding what this requirement means, we can address those so they don't continue going forward. But we are trying to get that quality review done before the team even leaves the laboratory.
Maybe I'll wait.
Yeah.
Maybe also people for chat.
Dan's been waiting
Now that
patiently.
you've pooled your resources, you have these lead assessors and you have your assessors, and they're pooled at the corporate level, I guess. How do you assure that those visiting a particular laboratory have the technical expertise to adequately, you know, ASCOD Lab only did forensic labs, so all of their assessors had expertise in forensic labs. You now have an accreditation system that looks at all different kinds of entities at the corporate level. You pooled your staff at the corporate level. How do you sort them back out to send the right people to the right lab?
So let me clarify. We did not pool the entire ANAB assessor pool. We pooled the ASCOD Lab assessor pool with the ANAB forensic assessor pool. So just within our strategic business unit, within ANAB, the forensic strategic business unit, all of our assessors are together now. But yes, we have a whole separate set of assessors that deal with laboratories that aren't forensic, medical laboratories.
So when you say these assessment documents get reviewed by the accreditation, if this is an accreditation person knowledgeable about forensic labs, not.
Yes, everything I'm talking about is specific to the forensic accreditation program. Our accreditation managers have all of them come from forensic laboratories. They have many, many years of experience in forensics, and so yes.
I've got a very basic question. We hear about on-site assessments, we hear about off-site assessments, self-assessments, and it seems like there's questions raised sometimes as to what these different things mean. Can you just give us a brief outline of the different types of assessments and when they happen?
Sure. So the first assessment is going to be the initial assessment for accreditation. And we are going to send a lead assessor and a team of technical assessors on site to the laboratory. Those technical assessors will need to have experience in the entire scope of what the requested scope of accreditation from the laboratory. So if they want to be accredited in biology and drug chemistry and toxicology, we have to send technical assessors with experience in all of those things to evaluate the competence of the laboratory personnel, the technical methods. We want to make sure everything's being done So that's the on-site. I don't know how much detail you want me to get in about what actually goes on, but they interview personnel, they witness testing being done or calibrations. We're talking about a calibration laboratory. They review case records, they review policies and procedures to make sure the laboratories not only do they have validated methods, but they're following validated methods. They review the proficiency test requirements because we have a very robust proficiency testing program on what the analysts and laboratories need to be doing to meet that. So we do sampling, so we don't look at every person every time. We take a sample and evaluate whether or not the laboratory is in conformance. If we see something that creates question, then we increase the sample size to see, is this a systemic issue? Is this a one-off? Then after initial accreditation, our typical process would be that the next year we would go back on site for a surveillance visit at about a 12-month period. Surveillance visits include sending a lead assessor. That lead assessor may have a technical background, and there may be one or more technical assessors that go with them. So they review a subset of the accreditation requirements. They don't review everything. So we're looking at the big things like internal audits, management reviews, the big issues with what the management system is set up to cover. So nonconformities that the laboratory has identified, and are they doing root cause analysis, putting corrective actions in place, and reviewing their corrective actions to ensure that they were effective. We look at, for example, training of new personnel. We look at proficiency testing requirements. Then the year following that, let's see if I did this right. We usually go on-site, off-site. So if we did an off-site review the next year, we would look at some of the same requirements that we were looking at on-site. We're just not going there to look at the records, so the laboratory would be sending us, their internal audit records, their management review records, any significant non-conformities. So there's certain things that the laboratory fills out a checklist for us and submits those records for our review. And so we go through this process. So you have the assessment, surveillance visit, off-site surveillance visit. There's a 4-year cycle. So when we get to that reaccreditation assessment, that reassessment is going to look the same as the initial assessment. Again, it's going to have that team that covers the entire scope of accreditation, and they're going to go through everything.
Thank you.
So just to clarify 2 points, because most of the labs in New York State are already accredited, it's our lab is going for an assessment in October, and then next year will be off-site. Then there'll be a mid-cycle review, right? The mid-review, and then the next will be off-site, and then it will be an assessment again.
Yes.
Okay.
So once the lab is up for reassessment, and the typical cycle would be we do a reassessment. The following year would be off-site. The year after that would be a surveillance visit at the mid-cycle. Then we do an off-site, and then we would do another reassessment. And the reason we go back at the 12-month period on the initial assessment is because we have yet to establish, that level of confidence with the laboratory that they're going to maintain conformance on their own. So if a laboratory did very poorly on a reassessment, we would likely be back in there the next year because we want to ensure that they're staying in conformance. And if we think that they need that extra monitoring, we would go back. But many of our laboratories have demonstrated to us that they can maintain conformance on their own. And so we do the off-site review and just go back at mid-cycle.
And just one thing, just to clarify, when your lead assessors and technical assessors walk in the door for an assessment, that's not the first time they see the laboratory's documents. There's a whole process 6 months before, or where they're seeing all the documents you would like to see, It just, sometimes people get the impression ASCAD Lab or ANAB walk in, and this is the first time they understand the quality management system. That's not correct, right?
Right. We see the laboratories have to fill out an application and what ASCAD Lab used to call a conformance file, and we have a checklist. So now we have this checklist that is electronic now, and laboratories will go through, and it's got all of the accreditation requirements in it from ISO IEC 17025 and the ANAB forensic accreditation requirements. And laboratories have to tell us how they meet each one of those. So that's the first thing the lead assessor does when they get that documentation is they go through it and they do a gap analysis to see if anything's missing. They give that information back to the laboratory and say, you're required to have a procedure for X, and I'm not seeing that. So that's something that we're going to need to talk about further. We might address it on site. Maybe you just didn't include it in the records that you sent. So the laboratory has an opportunity to see where the gaps may lie and get some additional information ready for the team when they get there. But yes, and then the technical assessors get all of the technical procedures ahead of time, and they review those before they get to the laboratory. So if there are significant issues with the procedures, they have likely had those questions already ready when they walk in the door that they're concerned about the procedures themselves.
Marvin?
So it's just some basic principles that we've had in the past, and we'll see if they're going to follow through with amen. If this commission disagrees with one of your rules and we enact a rule that's more stringent or less stringent than the rule that you have, will you abide by what this commission does in New York State?
I would say if you enacted something that was more stringent, we could certainly implement that. I think it would be very difficult for us to say something doesn't apply because it is part of our program and we've been evaluated and we're holding laboratories to that. That being said, if you think there's something that we've implemented that you think is significant and shouldn't apply, I certainly would like you to bring that to our attention.
Which is a good segue to the next question.
All right.
There was some consternation expressed in the forensic science laboratory community here regarding one of the requirements for a laboratory head's educational background. Could you go into that a little bit? I think what we saw was that the head of a lab didn't have to have a degree. What does that mean? Can we just put high school graduates in here in New York State and call it a day? Or maybe it just needs some clarification.
Sure. Yes, I know that was one of the concerns that we removed the specific supplemental requirement that said the laboratory had to have a director, and that requirement is back in the city. We added that. I think it's 415A1. Laboratory shall have a director whose duties shall be defined. The only reason we took that requirement out is because we felt it was already covered by 17025. That says you have to define your management structure and the authority of those individuals. 17025 actually says the laboratory shall have managerial and technical personnel who, irrespective of other responsibilities, have the authority and resources needed to carry out their duties. So we felt that the laboratory already has to define their management structure, and this 17025 requires that they have authority to do their jobs. That we felt the supplemental requirement was just repeating that. That being said, it was a significant issue in the forensic community that they wanted to see that actual language in there, so we left it back in. We did not add in what used to be an ASCAD Lab supplemental note that said the laboratory director should have a degree. That note was not enforceable. It was never enforceable. It was not assessed to. It was a recommendation. We have clarified all of the notes in our current accreditation requirements are either clarification or examples of what the actual requirement says. We did not put best hold a laboratory to a no, only hold them to a requirement. So that's why you don't see the educational requirement. So to your point, Marvin, could a laboratory put somebody in without an education? Yes, they could. But they've always been able to do that. And they haven't. And, you know, we trust the good judgment of the laboratories.
And just two more areas quickly. It sounds from the assessment scheme that you have described that before you show up at a lab, for any kinds of research, you're going to notify the lab.
Yes.
Okay. Now, once you arrive at the lab and you fan out to go into the different sections, let's say you get to the fibers, what's your procedure for reviewing the files in the fiber section? Do you look and select the files, or do you ask the persons working there at the section to provide you with the files?
We do both, actually. So we ask the laboratory to have some files available for us, and the teams all have instruction that they are to pull additional cases while they are on site. I ask the laboratory. So we would go into the supervisor of that section and say, I need a list of your fiber cases. And the supervisor would come back with that list and we'd say, randomly pick up, I want to see this one, and this one. And the reason we do that is because we want to see, you know, just cases randomly selected that potentially the laboratory hasn't re-reviewed themselves. But also, we want cases that the laboratory has provided because we want to see a variety of conclusions. So what I don't want to do is go into a latent print lab and only look at cases that are no value. Right? It doesn't do me any good. I can't tell whether or not they can do an adequate comparison if every case that I randomly selected was no value. So we want the laboratory to provide us with a selection of cases that have, you know, they've made identifications, they've made exclusions, you know, there's some inconclusives, so we can see how they're reporting those different results. But then we take a random selection also to supplement that.
Last area for me, under the ASCLD lab regimen, there were three, or actually four possibilities after accreditation. One is the lab was accredited. The second was that the lab was placed on probation because it didn't meet the requirements, or the lab was suspended because it didn't meet the requirements, or I think we only had one case here that never got to it because the county acted before we could. That was Nassau County. Revocation. So we are a state that has a commission. My question to you is this. If we get into a situation where you've done these assessments and the lab is in trouble, and that's happened, how much lead time do you give to this commission for us to know that the lab is in trouble?
That's a good question.
Yeah. And it's asked because we went through a terrible situation here with Nassau County many, many years ago. This is new at Nassau. But not the old.
I thought you were fine.
No, this is new Nassau, and you can tell. But the old Nassau, we ran into a terrible situation where we're sitting here at a commission meeting, and we sit down, and we have a letter in front of us that the lab is in free fall. ASCLD lab has known this for about 18 days, and we go a little bit crazy. And out of that meeting, I think Bill Fitzpatrick made a motion, and I seconded it, and we had a 30-day opening for this lab to report back. In the meantime, the lab was shut. So I'd like to, has any thought been given to this? How does it work? Does it need to work?
Our agreement that we sign with each of the labs in DCJS says that we are going to contemporaneously provide communication. So if I was sending a letter to Pat regarding his laboratory, Brian would get copied on that. Brian's office would get copied on that. So I think that would be your source of the notification is we sent that in at the same time we towards you not having an open-ended, it can take them forever to come back into conformance with things. So we give them 60 days to come into conformance with those, anything that we issued as a non-conformity. But that being said, if there was a significant issue, particularly for an initial accreditation, it doesn't matter, they're not accredited yet, right? So we can't withdraw, we can't suspend, we can't sanction their accreditation because they're not accredited yet. But for reaccreditation, we certainly could, and we could suspend, if it was an issue in DNA, we could suspend DNA pending that those issues be fixed. And if we did that, I suspect we would be back on the site before we reinstated that.
Let me just, if I can ask a follow-up. Yeah, I think Marvin has asked you, and you've indicated that if New York wanted to put some extra protection or process in place, you'd be open to that. So let's say at the end of this process, we say we want to continue to work with your organization, but in the event one of your assessors, goes into a lab and finds something, or as a result of an offsite, you see something which immediately causes significant concern about the lab's ability to continue, or causes concern about whether or not they should be continuing to do forensic work, given what you saw. If we said, and we would have to flesh out what these parameters are, but if we said we want to know as a commission immediately, if your assessors walk in, or if you get something in an offsite, that causes you to say, wait a minute, this is a huge red flag, something needs, this needs attention immediately. If we said to you as a commission, we want to know that as soon as you learn it, that day, the next day, is that something that you would be open to?
Oh, yeah, absolutely.
All right.
Commissioner, I'll just ask though, if that kind of communication went from ANAB to the commission, it should be CC'd to the lab director.
Absolutely.
Because sometimes things just seem to go on without the lab director being aware.
Yeah, and I'm not suggesting for a minute that anything gets pulled right away. I'm just saying that, so that the commission doesn't get accused of abdicating their responsibility.
In the Nassau situation, the lab director was notified before the commission.
But
I'm just talking in general.
Point is a good one. We all ought to be notified, and then we can all decide whether or not it needs our immediate attention. So I think that's something we can look at as a commission.
Yeah, and that's something we want to work on, together to make sure that we're very clear on, what types of issues do you feel are significant enough that we need to be notified as soon as we see them.
The clear example, Maya, is you walk in and see that someone is dry labbing. Hopefully the minute you saw that, we would know about it. But so I think we're all on the same. Lydia, you've been waiting patiently.
No, that's fine. You mentioned earlier about an initial accreditation. So does that suggest that we're starting from scratch? No.
So initial is just for a brand new laboratory that is not accredited yet. So you would be reassessment. We'd reaccredit you.
Okay. I think I forgot the other thing that I wanted to say. It was a little bit too long.
Marvin's fault. Scott?
If I think of it.
Just I'd ask some of the lab directors, since you're here, if they had any questions. So I just would be remiss if I didn't have the opportunity to ask, if you don't mind. One was, I think I just want to be clear, because the way I interpret stuff might be different. But there is a new standard that talks about when ANAB says it's a non-conformity, there has to be a root cause analysis. That's during an assessment, correct? That is not during, we're looking at our paperwork and you disagree with our findings. It's during assessment, your lead assessor has decided this is a non-conformity. You expect a root cause analysis to be done on all of those, correct?
Yes, but there's one correction that I want to make to that, is that requirement is no longer in this document.
It's not? Okay, sorry.
So, I saw it on here and I wrote a note next to it, 41111.
Which one is it, 41111?
Yeah, so it's been removed.
You're very responsive. That's great.
Yeah. But that was the intent. If we wrote a nonconformity during our assessment, and I'll tell you the reason it was put in there is because as an accrediting body, we have to conform to ISO IEC 17011, and 17011 is changing as well.
Okay.
So it's not, again, I feel your pain with the changes to 17025 because they're changing the requirements that we're held to, and there was specific language changed in that document regarding us requiring a root cause analysis. But when we really stepped back and looked at it, you know, that the discussion centered around, well, if it's just a simple correction needed, then why would you have to do a root cause analysis? And what we landed on was, if it was just a simple correction, it's unlikely we would have written you a nonconformity during the assessment itself. Because a simple correction is, you know, hey, you left a page number off this document, you know, add the page number. And that might not rise to the level of a root cause analysis.
So just on page 2 of Brian's document.
Before you do that, do you remember the one?
Oh, I'm sorry.
I did. This is pretty simple. When our analysts or myself go to testify in court, one of the qualifying questions is, who is your lab accredited by? So what exactly are we saying now?
We don't know. We don't know. Because it's illegal.
I think we can let her answer that, right?
But yeah, I think we should let her answer, but then I think we're gonna have to have a discussion, and I've got a suggestion as to how we might do
so
it.
I was just interested in the verbiage and specific because
Yeah, it is a good question. So because legally we are the ANSI-ASQ National Accreditation Board now.
I'm sorry, can you say that again?
It's ANSI-ASQ National Accreditation Board.
That's what ANAB.
That's what ANAB stands for.
Okay.
And so, I mean, you could say you are accredited to the ASCLD Lab International program. You're accredited to ISO IEC 17025 and the ASCLD Lab International program. But technically, the accrediting body that now exists is ANAB.
Okay, thank you.
Sorry, Scott.
No.
I
Sorry.
think we've got all three.
So on page 2 of 2 is 5.94, and again, this is me probably asking you how we're going to do it. You want to give us flexibility, but a technical review of technical records, test reports, and testimony. So the change is the word testimony, and the being technical review. Now we have different ways of reviewing testimony. Most people have a paper trail with the members of the court who do it, generally the prosecutor, and some laboratories try to put technical experts out there. But this seems to mandate, if a technical review is to be done, it usually I thought would be documentation that is reviewed to ensure that the testimony was within the scope. And that means that we would have to start getting transcripts. Is that the intent of this?
So,
or are we sending people all across the state? Because some lab directors were saying, I only have 3 people in my lab, someone's testifying, I've got to now send someone to watch them.
So what we did is, there were multiple changes to this requirement, and so we put testimony in with the same requirement for technical review of technical records and reports because it's verbal reporting. And we added the element that technical reviews need to be conducted by somebody who's technically competent. That being said, we also are allowing the laboratory to define the frequency with which that happens. So it may be, if you've been using the, for my own personal experience, the laboratory I worked in used comment cards that were sent to the defense, the prosecutor, and they would fill out the card regarding the analyst's testimony. That's still acceptable for your purposes to review testimony, but you also have to address, you have to have a procedure that somehow you are going to cover testimony review in each discipline with someone who is technically competent.
Okay.
It doesn't have to be every time you review testimony.
No, I understand.
In that discipline. You tell us, I'm going to do, every time an analyst goes to testify for the first time, I'm going to do that, and we're covered, or I'm going to do 10%.
But you are saying there's going to be a mandate, or not mandate, there's a standard for a technical expert to review testimony. I'm assuming the frequency will be less than annual because
The frequency is defined by the laboratory.
the file case
How
is
you're
defined by the
gonna do that.
laboratory.
Now, if you tell me you're gonna do it once every 10 years, you're probably.
No, you're going to have
see
no,
that
yeah,
We felt that really
is not
wasn't
acceptable.
the intent of the requirement.
But when I think of a technical review, just I think of looking at paperwork, not looking at a testimony in the courtroom. Do you believe that will be acceptable as a technical expert being in the courtroom and watching the testimony of one of my examiners?
Yes, that's the intent behind it. We want someone who's technically competent reviewing that testimony. So you could be in the courtroom listening,
Or you
could be looking at the transcripts.
You could have a conference after the testimony and before the testimony.
No, that's not.
Could you have an oral conference?
No.
If you were gonna, I don't think you'd be actually reviewing the testimony if you're doing it before or
How about
after.
after?
If you could have a conference.
I testify in the morning, I come back to the lab, you're my supervisor in the section. You ask me what happened.
That's not
I
acceptable.
wouldn't think so.
No, that's not. We wouldn't want you to do that. That's not meeting the spirit of what you.
Because I have to tell you, in September of 2010, we broached this question 3 times. Right? I was here. I was the one who asked the question. My first day on the commission. 3 lab directors, all self-certified, that they had looked at testimony. And then we asked them the question, and nobody had looked at the testimony. There wasn't a log, there wasn't a procedure, there was nothing. So the ASCLD lab rule that there be review of testimony was never enforced.
No, that's not. I think we're taking a little bit of context. I understand what you're saying. I'm not disagreeing that happened in 2010, but this is saying a technical review of testimony. Technical review of testimony has a different context than what was in the past, which was a somewhat review of courtroom testimony, which could be watching how I wear my, he's got a nice jacket on, he looks good, don't like the glasses though. No, I don't mean you. No, I would never speak about you, Marvin. It's Pat I'm talking about. You know what I mean? It could be demeanor, it could be poise, it could be the conclusion, where a technical review testimony, if you're taking the word, does the language, does the data support the conclusions? Does the oral testimony support what was written in the report and what was verbalized? So it's a higher level, which I think is good. It's the frequency, it's how we can achieve that. I think, anyway, so.
And the requirement, one of the aspects of the requirement is the laboratory has to tell us. So they have to, it requires a procedure. Our commission like that. It requires a procedure.
I love it. I think you're gonna run into problems in the state of New York. We have we have 20 now? 20 labs under our jurisdiction?
19, I thought.
Didn't we just add one in Greene County somewhere?
What's that?
DCJS Layton Print.
So how many? Yeah, we have 20.
20.
It wasn't Greene County, it was the DCJS Layton Print Lab.
Okay, I'm sorry. That's not Greene County.
No, that's in Albany
upstate.
County.
So there are 20 labs. And if you're right, yes, this rule would be a procedural rule that would be different than anything we've done before. I happen to think it's great.
Can I ask?
I think some labs are not going to think that's
The technical review, would that also include, for example, making sure that the conclusions were properly stated and not overstated, for example?
Yeah. Nice.
Yep. And
Yeah, no, I
so,
think
so there has to be a procedure.
It's good. It's just the burden on the laboratory. Like we have maybe 800 people go to court a year and 500 testify.
I
So
get that.
so it's great.
The flip side of it is you look at some of the issues on the national scene now that the FBI is dealing with, and if someone were conducting that type of review
have
of
less
testimony,
problems.
hopefully it would be caught early on and we could deal with it. So.
But I just think it's just, again,
Yeah,
I think
no.
it's great, but as long as we always keep in mind there is always a burden to do it, and I think the lab directors are not against moving forward with this. I think they've already been doing it to some extent. My own laboratory, we did a huge review of people's testimony. I just think we need to recognise that there's always a cost, either in personnel, money, in regards to getting to a standard. You know what I mean? Standards don't just happen by will, they happen by resources and by funding.
And we got a lot of feedback when we put out that initial version of the requirements where we had annual review required of
Just
analysts.
follow up on that.
And so it was a big operational impact with some labs traveling for hours to get an analyst to testify. the amount of time that takes with resources. And so that's why we changed the requirement to say the laboratory has to ensure that each discipline gets reviewed. The laboratory has to tell us with what frequency, how are you going to do this? What method are you going to use or methods to get this done? But it gave the laboratory some flexibility with their operation to make sure that, maybe they can video conference in and watch the testimony going on. Maybe they get a recording. They might send somebody. Maybe they send somebody from, another accredited laboratory who has reviewed their procedures to go and provide that independent review of, is this person, testifying in the confines of what the laboratory is accredited to do.
This is one of the things that's good, and we're just going to get there.
Yeah, Ann's been dying to follow up.
There's the cost issue to the lab in compliance, and that's going to depend on what the lab. This is the cost question. Do you anticipate is there any cost implication to the lab for what they have to pay to the accrediting organizations for their accreditation?
We have revised the fee structure, trying to mesh the two, because A&B had a very different fee structure from ASCLD Lab. And so we have put through painstaking effort to try to keep it from any substantial cost increase, cost change to laboratories. So while you may see an increase in, and I can't tell you specifically, but I'll say maybe you saw an increase in your assessment cost, but you saw a decrease in your annual fee. So we're trying to keep the overall cost of the accreditation for that cycle from
The actual
increasing.
direct payment to A&B costs are being managed at minimal.
Yes.
Judge, did you have a question?
Yes, and it's probably answered because I have a lack of technical knowledge, but
That makes two of us.
on page 1, there was one item that was removed regarding the maintenance of calibration records, and
You have a number?
it just says removed. It's in the middle of
There's
page
no
1.
number.
And I just wanted to be sure that there are records maintained of how these instruments are calibrated, so that during the trial, the defense attorney has the opportunity to probe whether or not the machinery is technically up to standards, and that these things are available for
Yes.
discovery.
So what was removed was the ASCLD lab requirement that said when instrumental analysis are conducted, operating parameters shall be recorded. We removed that simply because if you go to ISO IEC 17025, it already tells you have to do that.
So the things are
it was
there.
duplicative.
So they're
So
there.
it is there. They have to maintain those records. We just didn't feel like we needed to say it again.
Question clarification then to Brian. Are all of our New York State labs now ISO international
No.
accredited? No.
Because the toxicology laboratories under ABFT still are not. So you've got 12 laboratories of the 20 under the ANAB ASCOD lab program, and the other 8 are under ABFT.
Are all those that were ASCLD that presumably are now moving to ANAB ISO?
Yes.
Okay. And so they're already having to do that. Okay, that was.
Any other?
Just one last thing, I'm sorry. And
No, don't apologize.
You ask a lot of questions.
Well, I asked the lab directors to give me them, so it's not all me.
Make you sit next to Marvin next time.
Oh, wait, is that what happens?
He's got a very pleasant voice to listen to.
I spoke too much the last time, I guess. I don't know.
And that pays for radio.
Thanks, man.
Where did that come from?
I know. We won't. Anyway. So just the last thing is the scope is changing. So, laboratories have a discipline and category of testing. So I don't think we have to go into it right now. I just think, will there be more conversations with, I think this is maybe even for the state, because each lab does their own way of doing what they fall under for their discipline and their category of testing. And now we've transitioned towards ANAB, and they're changing it again. I think it'd be something we should look into in regards to written documents. I think it'd be hard to verbalize the point I'm trying to make right now, except that there are changes coming where something that used to fall under the criminalistics discipline might not exist under a category of testing. It's going to fall under a different language structure. Is that correct?
So I can give you like an example off the top of my head would be bloodstain pattern analysis. That used to fall under crime scene. It will now be a standalone discipline.
So I just think it's
So
something
there
that we should
are
talk
changes.
about as we're moving forward. That's all.
Okay.
That's
Not now,
all.
but
Not now.
We
Not
don't
now.
have
No.
the term category will no longer be on
Yeah.
the scopes in the new structure.
Yeah,
We're
so that's-
moving to kind of fall in line with the OSAC structure and the subcommittees that they've developed to address each of those different areas of forensic science.
And the last thing is just my own laboratory is going for assessment in October, so we're not trying to meet the new accreditation requirements. But other labs will over the next 6 to 9 months. Do you have any percentage of what labs you think might be having an on-site visit? And there's a thought too that once you do that on-site visit and you see issues that are coming from the interpretation, would you be issuing any possible guidance documents? I know we talked about the board still exists in a different form, but again, I'm looking to wait a little bit because there's going to be different interpretations. I'm just wondering, is ANAB thinking of including a guidance document as the next 18 months progress?
We don't have any specific plans for creating new guidance documents or, what were board interpretations. But that being said, we want our laboratories to be successful. And so if we're seeing something come up and we say, clearly this is not worded properly, we have the ability to either modify the language of the requirement so that people understand it, or certainly communicate with the laboratories like, hey, there seems to be a question here, and laboratories are not meeting the expectations, so we want to clarify what that is. We will be providing some training to laboratories that should be announced sometime this month, multiple training sessions on that transition process, and I suspect that we will record one of those sessions, one or more of those sessions, so that laboratories that couldn't participate could watch it at some other point. But certainly, we want to do everything we can to help you be successful the first time through. So we're going to go through and talk about the changes to the requirements, how the transition will work, and answer any of those questions. So I'm sure you probably still have more questions.
Yeah, but I'm not going to add too many evil looks from Pat.
Thank you very much. We appreciate you coming in and taking the time to talk to us. I think this is very helpful. So again, you can be excused.
So that's a legal issue, right?
Well, yeah, so I was going to say I have two suggestions. The first, in terms of process, since we did as a commission say we wanted to look at all of the available options, I think tentatively our plan is to have A2LA, who's asked to come in and talk with the commission, come in September, talk to us at the September meeting, have ABFT come in, or at least offer them the opportunity to come in December and talk to us at the December meeting, with the intention of hopefully bringing all this to a head and making decisions at that December meeting as to what path we want to take forward as a commission. In the meantime, we have this issue, we have the regs, and it's 9 New York Code of Rules and Regulations, 6190, and then it's in 1:1 I think it's in that same 6190.3.4.5.6, where we refer to as-clad lab. I hate to go through the regulatory process of changing that only to change it again in December if we decide to do something different in December. So I don't, my suggestion would be that if we as a commission could recognize the fact that ANAB has assumed all of the rights and liabilities of ASCLD, and recognize that any reference in the regulations, at least until that December meeting, should be deemed to refer to the ASCLD lab section or program that has now been assumed by ANAB, with the understanding that we're in the middle of this process, that we intend to make decisions at the December meeting, and that we will make a permanent change to the regulations consistent with whatever decision we make at the December meeting. So I don't know, is that agreeable with everyone?
Yes.
All right. Do we need a motion, or should we have a? All right, so I would make a motion conforming to what I just said.
Second.
All right, thank you. Any other discussion? All in favor? Anyone opposed? All right, thank you. All right, I think that takes us to laboratory disclosures.
Before we do that, Dr. Harton is available if Dr. Walsh wanted to talk to her quick. And I think it's just a quick clarification.
Yeah, no,
we'll go through.
absolutely. Let's do that now.
Oh.
If you want to go out of order too, Dr. Hartman can also address the second non-conformance report. So when we have on the phone, we'll just two birds with one stone if there's questions about it.
Hi, is this Rebecca?
Yes, it is.
Hi, Rebecca, it's Shelley. You're on with the commission?
Thank you. Hi.
Hello. Ann, you had a question?
Hi, yeah, thanks for coming on. Just a clarification in the first paragraph of the mid-cycle review report. It references a statement that says, in 2016, we plan to replace our TK and ELISA instrument. Is that just a typo?
It is a typo.
Okay.
I think it comes from, that was the initial plan, but we actually switched with a different instrument for last year. We just replaced an LCMS instead because that was a more immediate. So yeah, the 2016 left over from that. I didn't catch it, but it was basically it.
And you still plan to do that? It just
Yeah.
is down the line? Okay. And then just out of curiosity, your general comment is due to the resignation of a third of our lab personnel, there have been significant and substantial staff turnover in the last year. Just for our benefit, is there any particular reason why so many people left, or was it just, they reached that time in their life?
Yeah, it was coincidence. Just two people retired and another one was ready to move on to different things.
It's also a smaller lab, so a third becomes a little more significant.
We can vote now.
Do you feel like you've recovered from that transition?
Somewhat, but it's still a long road because we're absolutely overwhelmed with the onslaught of cases with the heroin epidemic. And, it's tricky because people are still adjusting to new roles in the country, but mainly we're just having trouble keeping pace with the caseload with 9 people. And, the heroin epidemic being what it is.
Have you received the adequate resources to refill all those vacant positions?
Yeah, they are all refilled at this point.
Do you anticipate resources to expand your staff in light of the caseload?
Anticipate might be a strong word. That is something that we've been asking our county for no success so far. They actually tried to lobby in Albany, the state government, to get a little more support for our area, and so far nothing's really happened with that. It's something that we're struggling with, and we've been saying it for a long time. We need more people, and right now we don't have the capability to bring more people on without sustainable. The trouble with grant-funded positions is that they're not guaranteed to be there from one year to the next.
They don't work, yeah.
And so what we need is a sustainable, reliable source of income that can be added to the official budget to expand our staffing. And until that happens, we're kind of on the creek.
Thank you.
All right, so you were on the agenda. Oh, sorry. Did you have a question, Marvin, or Pat, or was your hand just gesticulating?
No, I think you're just talking.
Okay, so you were on the initial agenda for accreditation update, which was this follow-up, but you're also on for a disclosure. If anyone has any questions, just while we have Dr. Hartman on the phone, if not, we can.
This would be 7B.
Yeah.
On the agenda.
So page 420 in your binders. So close out of a previous reporting error, nonconformance.
All right, it doesn't appear that there's any questions, so thank you. We appreciate you spending the time with us.
Thank you. I'm sorry the call didn't go through before.
No, no problem at all. No problem.
Apologize for the change of order just since she was on the phone. The first one that we were talking about under the lab disclosures was Erie County. So again, there's documents in your binder on page 411 regarding a closeout of a nonconformance they had. We have lab management available if you have any questions. All right, next one down is Nassau County Office of the Chief Medical Examiner, Division of Forensic Services. And initial notification, page 423 of your binder. Dr. Buffalino is seated at this esteemed table if there's questions. Next one down, the New York City Office of Chief Medical Examiner, Department of Forensic Biology. It's a closeout of a previous notification, page 424 in your binders. Marvin?
So I just have one question about page 424 through 426.
Hold on a second. Hey, do you guys want to just pop up to the table? Thanks. And just identify yourselves when you get there.
Mary Wordsworth, Insurance Manager for the Department of Biology.
Very straightforward, simple question. I'm looking at page 424, 425, 426. Is this the RCA?
Yes.
This is what it is.
This is, no, I'm sorry. This is my letter to the commission letting you know how we remediated all of the findings from the RCA.
So I know New York City, the New York City Council had passed a full law governing this. They required the RCA. You had one, and you sent one into them.
And
Oh. I don't see.
It's referenced here. It's on October 26th.
2016-01.
That's our internal number for it, but on October 26th, we've already issued the final RCA report on that.
Right. So where is the RCA?
You've already seen it, I believe.
When you say he's already seen it, it was part of the materials for a previous meeting?
Correct.
All right, so can we get Marvin that information?
Absolutely.
Yeah, I don't think I saw it. If you
Sure.
can get it to me, I appreciate it.
No problem.
I just want to be sure that whatever the city council is getting, we're getting. Okay. That's
All right, the next laboratory is the New York City Police Department laboratory. Close out of a non-conforming event. And whatchamacallit, page 427 of your binders. Dr. O'Neill's available if there are questions. The next one down is the New York State Police. It's a notification of a non-conformance. This one's not within your binders. It's an additional document got at page 465. Members of the State Police are available if you have any questions. Okay. Next one, Suffolk County Office of the Chief Medical Examiner, Forensic Toxicology Laboratory. It's a closeout of a non-conformance, page 433 of your binders. We have members of the laboratory here if you have questions. All right. Last is the Westchester County Division of Forensic Toxicology. It's an initial notification and a closeout of a non-conforming event, page 439 of the binders. And we have laboratory management here, and if there are no questions, that ends the laboratory disclosure component.
Okay, the next item we have is executive session. Do I have a motion to here? That said, I just want to say again, I know we have differences of opinion on issues, but I think we had very good discussion. I think everybody, was very professional and forceful in articulating and airing their positions. And I appreciate the time and effort that everybody here put into the issues. I appreciate your advocacy and thank you for serving on the commission. With that, do we have a motion to
Mike,
adjourn?
I'll move to adjourn, but keep us posted on the training aspect.
Absolutely.
Thanks. I want to communicate that to our colleagues.
Yeah, absolutely.
And I move to adjourn.
Do we have a second?
Second.
You missed it.
You missed it.
Ian sucking at
All in
All in favor?
Still thinking of questions.
Our next meeting is September 13th. So thank
No.
you, everyone, and that won't be in Albany.
Well, meeting should be nothing to do.
Hey, Greg, can you tell us when the audio is off?
Drive down the freeway.
Isn't that better?
Can I just leave you all?
Absolutely.
Thank you.
It takes me 2 hours and 20 minutes to get to Albany.